Oh,
Yes.
maybe you are okay. I have on behalf of the ticket matter. I put down my report for withdrawal of the test. So I may be listed along with the picture or item. I'm withdrawing it. Item.
Okay. Maybe. Not on motion matter, may I pray for listing on Friday? Quite fine. We'll have it on Monday. Monday. Obvious.
One motion matter, it was last listed on 9/5. At this time, it was covered judgment.
Second,
That we clear. In item number 34, I have filed an affidavit in reply, which is not on record. May I please to allow me to bring it in record, affidavit in reply.
you want to call the
Yes.
reply?
Okay.
May I please your Lord? My Lord, I beg to mention for listing of the function item below, it was filed long back. Some error in the post title below, we have rectified it, even then it has not been listed. Now, my Lord, today morning I have been informed that the petitioner is going to be retired shortly. So correction of it, may I pray for listing on Friday? Some urgency is there that he is going to retire, my Lord, that will become fine. Online.
May I please, if I have filed an I, my lord, the matter may be listed on Friday, my lord, where there is some urgency.
What is the idea about?
My lord, in connection with with the repetition, my lord. Subsequently, my lord, the restaurant authority has published a notification for promotion and recruitment of professor, my lord. And I am the candidate, my lord. My right has been infringed, my lord. That is why anytime they may be recruitment may be.
Monday.
Wait, please, Bhagat, because I mentioned a pending matter, Bhagat, for listing for admission, man. Any day convenient to my lord.
Fourth of May.
May I please, there is for distinction lordship, 3 matters lordship, where filed on 16/5 lordship. So we want to title lordship.
That's right. Monday. Fourth May. 4th June.
May it please your lordships. Lordships, I beg to mention item number 56 of the daily list, your lordship. Lordship, we actually require 4 weeks time to file an affidavit in opposition.
Was
I'm for senior counsel of PK Tiwari. So let the matter come out after 3 weeks, because the state government is also required to file affidavit apart from the private response.
Lordship, we appear for respondent number 6 to 11, your lordship. Private respondent.
okay.
Your
good name, please?
You Patak for senior counsel.
Not Mr. You Patak, and the council appearing on behalf of Mr. P. Diwari and the senior counsel. On request made by Mr.
T. Kashyap.
P. Kashyap, and the council. For the respondents, 6 to 11.
6 to 11.
How much? 3 weeks time.
4 weeks time would be better, your lord.
4 weeks time is allowed to file one.
Much of.
Take a look. Back to mention for lifting of a request. The matter is related to the family pension. Urgency is there. So can it be taken on Friday? Also, the Guwahati University has not filed their affidavit. The notice was issued in the month of May 2024. And the petitioner is only depending upon the pension.
Okay. 28th of
Much of it.
That is the lordship. A lordship by mention one that was filed on 14/5/24. On
28th.
28th of last.
I beg to mention one repetition regarding family pension matter. Justice service is also complete. So much may be taken day after tomorrow, may not keep to lordship or any other date as a lordship.
6 June.
6th
6th of June.
may not maybe holiday may not. Eid is there.
What is that?
Eid festival is there, I think. Some earlier date on 4th May.
4th.
Another matter regarding provincialization, and I have an engagement with my senior counsel. Get it for me, come on court now, 2 matters. That's
For question number 1.
May I please develop
Yeah.
this? Case relates to compassionate appointment matter. The wife of the husband of the petitioner, my lord, died on 29/5/2016.
Mm.
Then she applied, wife, I mean to say, 27/7/2016.
My lord, we have filed affidavit. And also for the
You have 40
for
Respondent, BTC.
BTC.
my lord, it may be taken on admission.
Well, notice was not issued.
Not issued.
So we can hear it today.
Yes. Since notice is not sure, Lordship can take up the matter at the motion.
You're not prepared today.
My lord, the
Yes, proceed.
Yes. Then Lordship, she applied, my lord,
Who? Your husband?
husband.
Oh.
Then what happened, my lord, they have filed in, that is annexure 21 application. 21 and 20,
Annexure.
annexure D. If it's D.
Yes.
Then Lordship, then 21, that is the standard form. Standard form,
Right.
yes. my lord. Then headmaster of the said school forwarded letter to the inspector school regarding this matter, my lord. Then they have filed a critic matter. Because I have not received any minute of the, I mean to say minute of the meeting, my lord. Then they have filed one affidavit, my lord. Lordship kindly peruse the affidavit along with the minute, that is page 29.
Yeah.
Her name is shown, Rina Boro, serial number 7.
Okay.
Then the posts are 378. The strength of the post, gather post, it is shown as a 378. After the application of the grade 4, next, as per the total strength of the gather of the 4 posts of the grade 4 post of the secondary, Lordship got it? 378. Then Lordship kindly turn page 30,
378.
poster there. Then Lordship,
Post applied for grade 4.
I am applying for grade 4. Then turn page 30, Lordship. The rejection matter. Rina Boro rejected on the ground of under qualification.
Who is that?
Page 30.
What is your name?
That is 2.
Okay.
Serial number 2.
Yes, yes.
District Selection Committee could not recommend the following candidate on the ground as mentioned below. That rejected on the ground of under qualification. And Lordship kindly peruse page para 4. They stated that everything is strictly adherence to the government memorandum, that is 16/2015. Then I have filed reply. In this, and annex the memorandum of memorandum, my lord, office memorandum, where it is stated that Lordship kindly turn page 40.
But Devi, you'll have to challenge the DLC manual.
No, my lord, Lordship kindly,
We are coming to close 15, isn't it?
yes. No, 19, my lord. Para 40. That rejection order is not applicable because where a widow is appointed on compassionate ground to the grade 4 post, she will be exempted from the requirement of educational qualification. It is stated that in spite of that, they have been rejected.
my lord, there is a provision they have provided that
Yes,
this of the provision will be satisfactorily with our.
and my lord, my lord, for the post of grade 4, it is applicable
after the publishing of the Education Act 2017, but my husband is died 2016. It is not applicable because earlier also the person having passed my lord class 8, 9, 7, they were already been got the appointment, my lord, after obtaining the order from this honorable court. But in this case, they have stated that I am not qualified to be hold as a post of.
That's why,
Yes.
that's why.
But my lord, that all the selected candidates, all are without, all are 10 pass.
How about,
I have passed 9.
maybe we can come to this
Yes.
close 9 later on.
Yeah.
But then you have to challenge the DLC minutes,
Yes,
saying that in view of close 9, DLC minutes should be set aside. Here, you have not challenged, this is coming by way of.
So
an
because
affidavit.
I did not get my, so I approached
So-
this
so
honorable
you-
court.
That's why.
Yes, yes,
you
you
did
are
not-
absolutely
So
correct.
now through the affidavit and position, you've got it.
Yeah.
So the question of delay is not there,
Yes,
correct? Question of delay is no more there.
yes.
So now you have to file
I have to file, yes, another.
challenging this minute,
Right.
explaining that the minute was enclosed in the
Yes,
affidavit
yes,
in
yes,
opposition,
absolutely.
and therefore I have no knowledge. There's no delay in appointing this. That's all.
Yes,
So what do you want to do? You want to file a separate petition?
separate petition.
And
So
with your-
kindly mention the delay of this
No, you want to keep this pending or? want
pending,
to-
pending, madam. Pending, I will file by, day after tomorrow, I'll file, fix this matter along with this petition. Again, they will file affidavit and it will take time,
MS K Devi Learner Council for the petitioner
attend for a week.
submits that the BTC authorities
After, okay,
in the affidavit in opposition
this correct.
has annexed a copy of the DLC minutes.
Mhm.
Where's that minutes? Of the DLC minutes of Buxa district. Wherein the case of the petitioner has been rejected on the ground of being underqualified. Stop. She further submits that the petitioner is made aware of the DLC minutes only through the affidavit filed by the petition authorities. And
Yeah,
accordingly, she prays for 1 week time
1 week time.
to file another petition challenging
I
the
do.
minutes. Praise the Lord, please after 1 week. Or you withdraw this and file afresh.
No, after that, I will go. I live like. But he was getting like years.
Yes, Chisti.
May I please have the Novabal. Last time my senior friend took time, to obtain the inspection, perhaps it's not available.
No, lordship, we have not received yet, lordship. Can you fix it on Monday, lordship?
I'll fix it on witness day.
It is very limited. Except me, everybody has been regularized.
But yeah, we are.
It's
Which is still understanding council and school election. Just not on 28 to enable him to receive for the information.
Obliged. Sort of putting the area to the.
Made please, your lord. My lord, this matter pertaining to reservation of physically disabled person in the cadre of IS, Inspector of School, ma'am. On last occasion, kindly predict, my lord, the Secretary Education produced a letter
Yes.
dated 8/5, my lord, wherein the APSC was requested to give a corrigenda.
Lordship, upon receiving a letter from the secretary, we have replied this letter.
Yes,
Now we have to take it, I have already communicated with PhD, submitted the 3 minutes back, I have already given secondary copy. By Monday, I will get a thing and along with offer.
Let it be on Monday, man.
for G. Baisha, learner council.
Man,
Mr. P.P. Tata, learner standing council appeals. On instructions submits that the FPSC is not authorized to insert a provision of 4% reservation of PWD candidates with respect to the recruitment to the post of Inspector of Schools, DEO, Deputy Director. Inasmuch as it is the concerned department who is responsible for determining appropriate reservations based on the category strength of the post with proper identification and suitability for persons with benchmark disabilities. Within the PWD stop. Therefore, stop. Accordingly, the Secretary Assam Public Service Commission by communication dated 16th May 2025 has written to the Secretary to the Governor of Assam, Department of School Education. Stop. Para Mr. Assembly Chiefly, Standing Council, School Education Department. Praise for some time to enable him to receive instructions. Stop. Para accordingly, list the matter on Monday, Chiefly.
yeah,
Can you get it?
Monday. Monday, Monday.
Are you ready? 21, page 21.
Monday, 20th, 20th.
List the matter on 28. The communication dated 16th May is placed on report. I'm placing it on record.
Oblige, man.
Item 4 lawsuits, we have filed an affidavit yesterday, I think. Now in this regard, we have to file one more additional affidavit.
Oh,
Yes, lawsuit, and moreover, lawsuit in this case, lawsuit, department has requested Mr. Additional Advocate General to appear lawsuit. So matter may kindly fix on 5th of June.
so that's till then,
In the meantime, no, we have already stopped. On last date, I have submitted on my statement lawsuit, and we have already stopped that preparation of final
I'll
gradation list.
record that.
Yes. We have not prepared the final gradation list. lawsuit.
Only issue is very limited, my lord. The cabinet took a decision that our initial pay.
Everything will be hard.
Should be from
We
the
addressed by the,
If my learned senior friend has given assurance that the process will not
yes,
go on.
we have stopped on, last day I have submitted with the construct, with the instruction lawsuit.
What we have and council. Mr. Assembly Chiefly and Standing Council Secretary Education Department submits that he has filed an affidavit in opposition on 20. Yesterday you filed it
Yesterday,
on
yes.
25.
I want to file an additional more.
He further pressed for some time to enable him to file an additional affidavit. Press allowed, release the matter on 5th.
Fifth of June.
Para. No, don't say like that. No, for filing an additional. He further submits that till the next suitable last week, no steps will be taken by the respondents
For violation of the,
with regard to the promotion.
no, regarding, final gradation list, publication of final gradation list.
Will be taken by the respondents with regard to publication. of
Final
the
gradation list.
Final gradation list of
Of,
My lord, for the purpose of promotion of headmaster and high school.
For looking for
for the purpose of promotion to the post of headmaster in Lakshmipur district. Smart. Accordingly, the prayer is allowed, list the matter on 5th.
And in this case, notice can be issued so that affidavit, we will also file, we are filing affidavit.
Let the instruction come properly, not that because interim order is required. On his submission, it will be given.
Yes,
Obliged.
Fine.
Last order, your lordship, I can, if they are, your person to your lordship order, they were reinstated in service. They are serving, but from 2019 onward, they are not getting service. But to others, other person, they are getting money. Other contractual, similarly situated person, page 42. A highly qualified person, sir. They, actually, they should go for regularization by way of advertisement. Well, let them give the proper full instructions within a week time. They are paying to the other, page 42.
Yes.
Page 33 of the PPT. Wherein object, the principal head, to release the, how to release the salary of the contractor, page 33 to the direct. So from the principal. Then,
Then page 35, your lord.
page 35. I think that very perfect. With reference to the subject and
That we have seen it.
yeah.
You wanted to know how we are going to pay the salary.
Yes, sir.
Basic, we fix it from a college fund.
So that some governing body has also taken.
Hmm. This is not, see, others are getting salaries. Here said their pay would be released subject to establishment of a, dedicated college development. You have not, established a college development fund. No.
Then next week, let it come with the bocho. They cannot do it in this manner. It's in 2019, they are not paying.
Okay, I'll issue notice, but I'll give you 2 weeks time to file affidavit. That's all.
And pay the,
Within 2 weeks, I do.
not affidavit, they have to release the fund. Release the salary.
What Mr. P.D. does, and the senior counsel assisted by Mr. T. Legal. Does the council. Issue notice. Mr. A.R. Tabulan, the National Council, higher division,
Not I
appears on behalf of,
all that,
including the principal,
putting the principal.
appears on behalf of all the respondents. And prays for, 2 weeks time to receive instructions and or file a. Prayers a lot. List the matter on, give a date of the 2 weeks.
Nine.
Kind of.
But in the meantime, they may
Fine.
release the amount.
No, that's. But then, you can't do
Yes,
like this.
I'll do it. 9 June. Prior to the attack.
No bar for releasing the.
Pendency of this shall not be a bar on the part of the respondents to release the salary.
And see, here I have received my instruction. We want to file an affidavit notice. This matter also kindly picked it on 5th of June notice.
Notice has not been issued, but that notice be issued, they will file the application so that I can.
I'll issue notice. Interim order will continue.
So far as interim order lawsuit is still today, because interim order against the final gradation list. So if your lawsuit continue the interim order, they have to make the selected candidate as a party lawsuit. They will be aggrieved lawsuit. They will be president.
Okay, we'll issue notice there, see what happens. on the
Now,
fifth.
so far as the Chichago lawsuit, we have stopped this. We have stopped this process till now. Lawsuit.
So till fifth, you wait.
Yeah.
But it is cycle, senior council assisted by Ms. M. Nigola. How many respondents are here?
Three.
All respondents.
No, respondents still, we have time for.
Mr. SMT Chishti, Leonard.
Yeah, for all.
Standing council, secretary, division,
For all.
appears on behalf of all the respondents. And press and submits. You're filing affidavit.
Yes, I am finding it.
That you will be filing affidavit on or before the 5th of June 2025. Stop. Accordingly, list the matter on field view. Till the next, interim order pass to continue till the next.
Since they will be filing by 5th of June, madam,
No, have you filed earlier than?
When can you file it?
I'll file it by 30th of May.
File it. Affidavit on or before 30 May. Accordingly, list the matter.
I'll submit on 30th of May so that he can reply.
problem. The interim order.
Interim order first.
That you kindly pass over time for the time being. Near the teacher month will leak.
Item number.
The petitioner has challenged the impugn penalty order in lawsuit. As well
Where is
as
the order?
This is originated from the internal complaint committee report, your lawsuit.
Where is
Here,
the order?
impugn penalty order is page 99, your lord. His right is impugn penalty order, lordship.
This was issued out
Lordship,
1610.
lordship. Lordship, 16 says it was not issued to me. I have categorically made my statement. I have filed a writ petition before the Honorable Court. And during course of the writ petition, your lordship, hearing this penalty order was provided, and accordingly, I have filed this writ petition after withdrawal of that.
Lordship, a copy is endorsed to you.
Lordship, but that was not communicated. Lordship, but the statement may kindly see lordship page 20, lordship, para 7. Page 20. Para 70, lordship, may I read, lordship? The petitioner petitioner to after withdrawal of the writ petitioner report before the honorable report responsibility by preparing an appeal dated 20th to 24th as impugned, but despite lapse of more than 1.5 months of the respondent authority, neither considered the appeal preferred by the petitioner, nor any weightage is raised by the petitioner in his appeal dated month. Despite repeated requests made by the petitioner once again complained to appeal before the honorable court, filing under.
We'll issue notice then.
Lordship, the issue is here, your lordship, is the procedure under the provision of section.
That let them file the
has to be
affidavit.
followed, but
We'll
before the recommendation made, no any inquiry report was submitted to me. That opportunity was not given to me, and on the basis of that recommendation, the departmental proceeding was issued, and the impugn penalty order has been passed.
Third L. Mohan, done the possible. Issue notice. Mr. B.B. Bora, Leonard, standing council, Health Department.
For respond number 126, madam.
Appears on behalf of the respondent number, internal committee also,
Yes, madam.
1 to 6. Well, extra copies. Petitioner to take steps for service of notice on the respond number 7 by registered post AD within 1 week.
Okay. Who responded number 7, please? Who responded number 7?
No, you have to take
Sorry,
steps on respond.
responded number 5 will not. Who responded number 5 is because where is putting it, I do not have any. Exactly. I mentioned in The
No, that is then your respondent number 7's address.
lordship. But she was that time, it was a student of third senior law. That is where. So respondent number 5 lordship, notice will be.
See the address of respondent number 7.
Respondent number 7 is the petty, Department of Petty, Medical College.
Care of,
Lord.
so that will suffice.
Lord.
Respondents are not valid. Please suppose.
The issue not a debt is the law.
No, I'm not speaking.
Obliged matter.
Or lordship notice is to take in care of.
Reference room shall be considered on the next meeting.
Okay.
Lord, my instruction from the university is that, Lord, both the papers, Lord, the petition and for 0 marks. Both the papers.
Also may call for a record because
Then we'll issue notice and you produce report. Issue notice. Mr. PG Fupan, understanding council Guwahati University. Appears on behalf of
Respondent 1, 2, and 4.
1, 2,
Three principal school of
extra copies. Petitioner takes the for service of office and respond number 2 by registered. Respondents are Para. Mr. PG Fupan, understanding council Guwahati University. Shall also produce the reports by the next meeting. This after 4 weeks.
my lord, the examination will be held on 17th of June, my lord. It may be before that.
Then it has to go by registered post. Can you take dusty also on respondent number 3?
nearby to the school of
Then on top, where is it? By the one with the para additionally. Petitioner is also permitted post service of notice on the respondent number 3 by dusty service to the registry spot within 1 week. After petitioner shall file an affidavit. Then that's para, which produces one and the same shall also produce a report by the next. Your exam is when?
17th of June, my something.
Okay. Use the letter of 9 June.
Yes, my lord, recovery, my lord. Supposed to recover the petitioner before your lordship is a grade K employee, my lord. After the retirement, petitioner, they have calculated, the accountant calculated that
Where is
they
that calculation?
pays, my lord, 17, my lord, annexure 1. Due to wrong calculation of grade pay,
One
in
minute.
page 17, annexure 1, in inviting reference to your letter numbers regarding finalization of the pension case, the Bhairav Chandra Das retired senior assistant and state that the pay of the incumbent as on 1/7/2010 recorded in the service book rupees 13,760 as such is paid fixed as on 1/1/11 at rupees 20 with great pay 20 and hence 220 is recorded rupees 15,240 which is not in order. In view of the facts stated above, I am constrained to return the here the pension case, including service book, in original with request to resubmit the same after making necessary correction of the grade pay with effect from 1/1/2011 till date the retirement and also record the same in the service book with duly signed by the DTO and incorporated the excess recovery form 19 to the A fresh LPC, IPC may also be furnished. As regards the waiving of recovery, you may consult with the finance department.
Oh, right, I've seen that. Then what happened?
Thereafter, what is happened, my lord? Petitioner also submitted not to, my lord, to waive this, my lord, excess royal, my lord. Here subsequently, my lord, excess royal amount is, my lord, only, my lord, what has been calculated, 2,81,817, my lord. Here, letter 1 and letter, my lord, page 23, annexure 6, what the inspector wrote, my lord. Address to the Director of Secondary Education, page 23, annexure 6, in compliance with the contents as brought our out in the letter of substance, I have honor to apprise that the Bhairav Das assistant, senior assistant proceeded retirement on 29/2/2020. Subsequently, the then inspector of the school GDC has initiated all sorts of activity in regards with his family pension and later on, as your instruction on the body of your aforesaid letter, the personnel find the other relevant records are verified along with the service book. It is learned that the amount of rupees 15,240 has been fixed at rupees on 1/11/11 as stated in your letter. Letter. Noted that the then inspector of the school Abdul Jalil is now retired, put his signature again the fixation, and the then accountant Anwar Hussain, now retired of Golpara, made the entry of the fixation in service book, and his initial is also seen beneath the seal of the inspector. And the undersigned has gone through all the papers, and identification has now come to the light for my knowledge, and believe the then inspector of the school and the accountant as noted above may perhaps be fixed and recorded wrongly in the service. So, my lord, my inspector of the school and the accountant has committed a mistake of giving the announcement, my lord, in the month of my lord January instead of the November. Subsequently, my lord, petitioner, my lord, submitted representation and different time, my lord, addressed to the director of secondary education to waive the and to release his family pension, my lord, pension, sorry, my lord, pension and benefit, retirement benefit, but it has not been released. Already, my lord, there is a cover judgment I have also annexed here, my
Okay.
lord. Same facts also.
Third HDAS level council. Issue notice. MS Sharma, standing council.
For 1, 3, 4, and 7 lotteries.
Profit must carefully covered.
Secretary division. Address for the respondents. 1,
1, 3, 4, and 7.
4, and
7.
7.
Equal 5.
MS Arun Baro, level standing council, finance department. Address for the respondents. 2 and 6. Mr. P. Chakravarti, level standing council, accountant general. Address for the respondent. Extra office. Respondents are out of line. Listen before it's. Till the next speaker, till the next speaker, will do this. The respondents shall not make any recovery. Recovery is not done yet.
Not done, but they have projected, but that's why he has not given the pen.
Any recovery with regard to the payment of excess salary.
Get, my lord,
After 4 weeks.
other thing is 5 years to their pension, my lord. Only because of that, the mistake of the.
Let it come
official
after 4 weeks, after 4 weeks, it doesn't come, we make a mention. Up to possible results.
And big fight.
On this case.
Plead your lordship.
Yes.
My lord, petitioner, before your lordship, my lord, he was appointed as an assistant professor in the year 2000, my lord. Year 2000, my lord. Advertisement, annex 1 is the advertisement. Your lordship, can you see the page 18, my lord?
Page.
Page 18, my lord.
Oh.
I am in discipline of physics, my lord. So,
Your physics, one post.
one post. So it was a sanction post, my lord. So following the sanction,
This is what date?
my lord.
What date?
That is, my lord, that is 6/5/2000, my lord.
6/5/2000.
5/2000.
Okay.
Long back, my lord. It was a sanction post. I want to see that, my lord. In the advertisement, it very clearly said that it is sanction post, my lord. So accordingly, I was selected, and my your lordship kindly see annex 3, my lord.
Where the section for?
Annex 3, my lord, page 21.
Oh.
So that as per resolution number 624, as per I think 24, as he hereby appointed the lecturer against the vacant sanction post by the of physics on the same consolidated pay of rupees 1,000 per month
you will be get usual pay scale after your appointment is approved by the DAC on computation of the conversion. So and so. So thereafter, my lord, your lordship kindly see another order. 17 to 2021, 2001, sorry. Annex up 4, page 22. Page 22, my lord.
Oh,
So resolution number, that the resolution of the, my lord, government has been approved, my lord. And appointment of the concerned the incumbent will be the subject to the clearing some net slate and field that has repeated as the provision and is liable to be discharge of revenue. Second, the incumbent council will draw the minimum scale of pay 8,000 PM during the provisional period and other allowances admissible under the rule as stated above. It is the resolution number 22 college approved. So that was approved, my lord. I am getting, my lord, 8,000 plus other allowances. So, my lord, thereafter, what happened, my lord? Already, my lord, as part of 6 pay commission, my lord, we are getting, my lord. Now 7 pay commission has come. So then I filed an application for upgradation, my lord, for my upgradation in the, my lord, 7 pay scale, 7 pay commission scale. Then, my lord, your lordship kindly see page annex of 5, page 25, my lord. Annex of 5, my lord. Page 25. In inviting reference to your letter in subject header, I am directed to request to kindly submit a proposal and pay me to the case following the minimum UGC basic pay 20 as per month, who are receiving UGC basic pay scale 18,000 or 18,000 and allowance. So that was, my lord, regarding my minimum pay scale, that was granted. So page 26, my lord. Annex 6, my lord. Page 26. That letter is very important, madam. Page 26. In an inviting a reference to your letter on subject cited above, I am directed to state that the government of Assam in Higher Education Department is pleased to allow minimum basic pay scale of 21,600 per month in place of rupees 8,000 per with the per month with the other allowances as admissible under this rule in respect of Muhammad Badaruzzaman Mira, Assistant Professor of the Department of Physics in SS College, Hailakandi, with effect from 18/1/2019 as per GOM letter dated so and so. This has the approval of the additional Chief Secretary of the Government of Assam Education Department. So, my lord, is persuasive that from 2019, my lord, I am getting this salary, my lord, as approved by the higher authority, my lord. So, my lord, by this time, my lord, in 2024, my lord, the 7th pay commission has come. So, I applied for, my lord, upgradation, my lord, for as part of 7 pay commission. That is, my lord, page 28, Annex 8, my lord. Annex 8, my lord. Annex 8, my lord, page 28, my lord. As you lord, upgradation of minimum pay of rupees 7,000 with other allowances admissible as per UGC division of pay scale under 7 pay commission with effect from 1/4/2016. Now, with reference to the subject cited above, I am directed to enclose here with the letter along with the enclosure exhibit Badaruzzaman Mira, Assistant Professor of the Department. So that was forwarded by, my lord, Additional Secretary of the Government of Assam to the Director of Higher Education. Then, my lord, this is the order passed by the Director of Higher Education, that is on page 29, Annex 9, my lord. Subject, my lord, at page 29, regarding upgradation of minimum pay of rupees 20. The lordship kindly state where go to the last para in of the page 29. In view of the above, it is stated that Mr. Badaruzzaman Mira, Assistant Professor of Department of Physics, Sri Kishan Sadar College, Hailakandi, has not fulfilled the condition as per clearance and net slate as he has been drawing the UGC basic pay of and admissible under with effect from 18/1/2019 till date and paid for the upgradation of the pay of rupees 20 as per the 7 pay commission on 1/4/2016. Government Assam is hereby Education Department is therefore requested to pass necessary instruction on this matter. So that, my lord, your lordship kindly see.
You've not cleared your net?
Net slate, my lord, not clear. If I clear net slate, then I will get the UGC grant for commission. But otherwise, my lord, I will get the, my lord, the fixed pay plus allowances. That is as admissible, my lord, pay commission also admissible. That is comment of Assam. If my lord net slate, then I will get the UGC. That is defined, my lord. I am not on that, my lord. Now, what happened, my lord? The college authority also write a letter to the, my lord, that is Annex 31, Annex 11, page 31. Page 31. This is college authority also, my lord, recommend, my lord, regarding the upgradation of the allowing minimum pay, so that those who are underqualified, they'll get minimum, my lord. That is the law, my lord. And regarding upgradation of the allowing minimum UGC scale of pay in respect of the border media assistant professor. So that was also college also forwarded, my lord, for my upgradation, my lord. Now, my lord, your lordship kindly see page 33, my lord, Annex 12, my lord. Regarding upgradation of pay in respect of Muhammad Badruddin Mia, with reference to cited above, I have the honor to inform you that state that Mr. Badruddin Mia has appointed the lecturer, now assistant professor, Department of Physics SS College, Hailakani, the fixed pay of 8,000 with our allowances with condition that the net slap in party official interest. Subsequently, by government letter dated it has been allowed minimum UC basic pay of rupees 21,000 per month in place of 8,000 per month with effect from allowance as admissible under rule with effect from 18/1/2019. But the college authority has allowed pay scale of rupees 21,600 with other allowances instead of 21,600 by maintenance by misinterpreting the government letter dated dated 8/8/2019. I will come to that later again, my lord. With government has allowed minimum UGC basic pay of rupees 21,600. Meaning thereby I am entitled to get only 21,600, not other allowance, in place of 8,000 in provincial. In view of the above, the government of Assam Higher Education Department requested to pass necessary instruction in this regard. So accordingly, my lord, that annexer 13, page 34, that was passed, my lord. That was that order, my lord. Your lordship kindly straightway go to, my lord, last parameter, because that was selling before this honorable court, my lord. Earlier, my lord. Last parameter, page 34, my lord. However, as your lordship got it, my lord. However, owing to the misinterpretation of the government letter dated by college authority, Mr. Badruddin Zaman Mia has drawn an excess pay and allowances with effect from 18/1/2019, and same is liable to be recovered from him after calculation of the excess amount. The Director of Higher Education Assam is to take necessary action in recovery of the excess amount with reference to strength. So that order was challenged before this honorable court, madam. So on the ground that was passed, my lord, without hearing me, nothing, my lord. So, my lord, then my lord, this honorable court passed this order, my lord. That is, my lord, annexer 14, page 35, my lord. Based, my lord, my lord, relative para is, my lord, that is para 7, page 38, my lord. On considering the fact, has your lord, page 38, that is the main para of the earlier order, my lord, passed by the honorable court. On considering the page 38, my lord, on considering the impugned order dated 20/12/2014 issued by the Secretary of the Government of Assam Higher Education Department, having came to the finding that the petitioner had been received given an excess pay and allowances which is to be recovered without giving any notice and prior opportunity hearing the petitioner. This court is also viewed that the same is hid by the principle of national justice. Accordingly, impugned order dated 21/4/20 set aside. The Secretary of the Government of Assam Higher Education Department is given a liberty to issue notice to the petitioner regarding the condition that the impugned order dated 21/28 may take his decision as to whether the excess payment is allowed to has been given to the petitioner with whether the same is to be recovered with the petitioner. So accordingly, it was set aside and, my lord, demanded back, and then, my lord, they have given a notice to me, my lord. So I defend my case. Everything I have stated, that is not my misrepresentation, that is, my lord, that is as per law I am entitled. Now, my lord, after hearing me, my lord, same order they have passed. That's why now I'm before your lordship. Annexer 17, page 46, my lord. Everything the same order, same, my lord. Your lordship kindly, my lord, straightway goes the last portion. I am agree, but the last portion of the page, my lord, 46. Page 46. Instead of, my lord, giving 7 pay commission, my lord, they have given me, my lord, even what has they been given in 6 pay commission, that is also they're going to curtail, my lord. So page 17, my lord, or page 46, annex 17, last para, my lord. However, it is written that owing to the misrepresentation of the government letter number so and so dated 8/8/2019 by the college authority, Mr. Bodorojin Mia has been drawn an excess pay and allowances with effect from 18/1/2019. Same is liable to be recovered from him after calculation the same excess amount directing the student. So now your lordship kindly see by misinterpreting by the college authority on the letter dated 8/8/2019. What is the letter dated 8/8/2019? Your lordship kindly see page 26, my lord.
Yeah.
Page 26, my lord.
Yes.
So that letter, my lord, issued by Joint Secretary to the Government of Assam, which has the approval of the, my lord. Again, I am reading, my lord. There is no question of misinterpreting, my lord. That is the approval letter given by the, my lord. Your lordship kindly see. I am reading, my lord, page 26, my lord. In inviting reference to your letter on subject cited above, I am directed to state that Government of Assam in Higher Education Department is pleased to allow minimum UCG basic pay of rupees 21,600 per month in place of 8,000 per month with another allowances additional under rule in respect of the Bodorojin Mia Assistant Professor of Department Physics and Storage Hailakandi with effect from 18/1/2019 as per government letter dated so and so. That is not been available to me. That is not made available to me. It has the approval of the additional chief secretary to the Government of Assam Education Department. So it is approved by the minor authority. Now, my lord, that is been misinterpreted by the college authority, and that's why I'm giving him access allowance. So now, my lord, your lordship kindly examine the matter. Whole record may be placed before this honorable court, because already, my lord, they have, my lord, no order for recovery has been made, my lord, but they have issued a letter. Next para.
Mr. TJ Mandal, and it's near.
So that part only may interfere, my lord.
Mr. K. Mera, then it comes. Stop. Stay here, standing council, higher education. Appears for
1, 2, and 3.
respondents, 1, 2, 3. Extra copies. Petitioner participants, for service. On respondents, 4, 5, and 6. By registered person. Respondents are everything. Till the next meeting. No, we probably. In respect of access salary and allowances drawn by the commission. Shall we?
Develop.
I'm like.
Very compassionate effort. Earlier around this petition approach before the honorable court, but if I place FLC case 23 dollars. Page 23. Lordship order dated 21/8/23. Para 3 lordship, there is property person. Deals in non-body in meeting health, going to recommended case of business. I don't know, going to patients and before accepted committee. Is the case of the till that FLC is not considered as a business.
Then what happened?
And let to dispose of till that they have not placed, and in the meantime, this OM has come. This OM has come and got it placed right now. I want to.
Heard, Mr. Yes, you have met the counsel for the petition. Also heard MS. As detailed and standing council elementary division for the respondents, 1 and 4. 1 and 4. And MS as convert and it's government advocate for the respondents. The father of the petition late Jyotish. Is it Chandra?
Yes.
CH, Hello. While serving as a grade 4 employee in the office of the Block Elementary Education Officer. Comma. Park entry in the district of Malbari, Assam. Died on 15/4/2006. Stopped. The petitioner drafted an application for appointment on commissioner grounds on 8/5/2006. Stop. You have come twice.
Yes, sir.
As the case of the petitioner was not considered by the DLC, concerned DLC. The concerned district level committee, within bracket DLC. We approached this court by filing WBC number 3214 of 2006, which was disposed of on 26/11/2007, directing the concerned DLC to consider the case. But the DLC Nalbari, in its meeting held on 13/7/2012, recommended the case of the petitioner, along with 33 others, for placing the same before the state level committee. Stop. However, as the state level committee did not consider the case of the petitioner, he approached his court again by filing WBC number 4648 of 2023, which was disposed of on 21/8/2023, directing the SLC to consider the case for appointment on commissioner grounds in accordance with law, in its next immediate city. Stop. Then we said that in the meantime,
Yes, thank you.
Para learn government it is one of supplies that as the case of the petitioner has already been recommended by the DLC Nalbari in its meeting held on 13/7/2012. And further, in view of the order dated 3/4 passed in the PBC 3432 of 2025, and a batch of other issues. The case of the petitioner can now be considered by the SSC. Stop. Well, for the submission by the government. This petition is disposed of, directing the SSC to consider the case of the petition in terms of the recommendation made by the district level committee in its meeting held on 13/7/2012 in its next immediate city. Stop. However, if the case of the petition has already been considered by the SSC, the outcome of such consideration shall also be communicated to the petition court.
This matter relates to competition ground matter. The case of the petitioner has been recommended by the DLC, page 28. Dated 7/2/2024.
Where?
operative portion, page 30, serial number
Page 28. Page
page
30.
30, serial number 2.
Impal Kalita.
Serial number 2.
Oh, 2. Okay. Adipinath Maya.
State has been recommended for faithful vote in any department.
No. Yes.
Hereafter, my one has come and here, so my case was not placed in the assets. Therefore, I approach the court, challenging the victim when page 30.
Page.
Page 32, which number?
Which one?
In page 37, similar.
Were you a part of those batch of petitions which challenged the office memorandum?
No.
There's a writer in that paragraph of the judgment, isn't there?
I have seen my lord, but part of that, your lordship has directed for consideration. Other matter also, which were file after part of it.
Otherwise, Lordship, if I provide page number 30, Lordship, his date of birth is 33, 1975. And by that, your Lordship, his age is now 50 years and 1 month. Your Lordship, at the affidavit, he stated his age is only 45. It is also wrong, Lordship. And another thing is that, Lordship, his application was made on 25/9/1996, and his application was recommended. I don't know why or how, but recommended by 24.
The DLT has not rejected my case, my lord. Here is a two-part recommendation. One, authority has recommended.
That is the problem. Your DLC has considered the
The SIC will take a decision. If I am not eligible, I take it. If I am eligible, then in terms of recommendation made by the DLC.
But in that judgment, there is a writer.
Yes.
That it will be applicable only to cases that are filed prior to 3/4/2025.
In other cases, you would not consider that.
Okay,
Otherwise, Lordship, this is to be clarified, Lordship. He is,
okay, you want to take some time to clarify it?
no, Lordship, he has to clarify, Lordship. His affidavit is wrongly stated, his age, Lordship.
Where's his date of birth?
Page number 30,
Oh,
DOB 33/1975, Lordship.
I can't see his date of birth. Okay. 33/1975. Then,
His age, now his age is 50 years, 1 month, Lordship, but it is stated as age 45, Lordship, at affidavit.
Clarify my case.
It is stated 1975.
Maybe that is the
okay. But Mr. N. Sharma and hospital. Stop. By way of the present petition, the petitioner is claiming for consideration of his case by the state level court on the basis of the recommendation made by the district level committee. But with the in the meeting held on 7/3/22. So for completion level. By this week. Praying for considered for appointment on compulsory ground by the state level committee, huh? So, stop. But in the DLC minutes dated 7/2/2024, the date of birth of the petitioner is indicated as 33/1975. Stop. So a calculation would be
51.
50 years, 1 month road trip.
taking the date of birth as recorded in the minus of the DLC. The petitioner would now be about 50, would be more than 50 years. As on date. So, however, in the affidavit annexed to the writ petition, the date of birth of the petitioner is shown as 45 years. For Mr. N. Sharma, the counsel to the petitioner, shall file an additional affidavit clarifying the date of birth, as well as the age of the petitioner. This after 1 week, 2 weeks,
1 week.
1 week.
Yes.
This matter relates to compassionate appointment. And here, my lord, the petitioner case was rejected by the DLC, page 23, my lord. Page 23, serial number 11. The applications are rejected due to qualification not covered for the post of assistant teacher. My lord, here at the time when the petitioner submitted his application, the required qualification was higher secondary pass, and the petitioner was higher secondary pass at that particular time. And as per the circular dated 16/5/2012, my lord, the required qualification was higher secondary pass. Moreover, compassionate appointment, my lord, may be given as per qualification. So he approached the authorities, and the authorities assured him that in the next DLC his case. will be
DLC
placed.
meeting was held in 2017.
Yes, my lord.
Why are you coming so late?
My lord, he approached the authorities.
No,
I
if
have
you are approaching
stated-
the authorities, that's a different issue. But then immediately you should have challenged the DLC mining.
No, there are four
On the-
people, my lord. Compassionate
That is not
appointment.
the, what,
So they
have
got-
you explained the delay?
page, para 10, I have explained, my lord. Para 10, page 13, my lord. Page 13, the subpara, my lord. The aforesaid fact was pointed out by the petitioner to the respondent authorities, and accordingly, the petitioner was given assurance that his case would be placed again in subsequent DLC meeting for reconsideration. But subsequently, his case was not placed, and in the meantime,
When did you approach these authorities?
my lord, after, my lord, this rejection, my lord,
Where?
not immediately.
Okay. There's delay in the immediacy of completion, appointment on completion of grounds. It's no more than.
At least he has explained, my lord, they gave him assurance. At least after this rejection, he appeared, my lord. He, my lord, he
2017,
approached the authorities.
or
They gave
2005,
assurance that they will place the petitioner's case, but they did not place, my lord.
8 years delay there.
Yes. Subsequently, DLC meetings were held, but his case was not placed, my lord.
Why should we place, it is already rejected?
Because,
We
my
should
lord,
have-
it was rejected wrongly, my lord.
Maybe, if you had approached this court at that relevant point of time, maybe you would have got some relief, but today it's difficult. After 8 years, you are approaching this court.
My lord, he approached after, my lord, the rejection of
That's
2017.
why after
But it
rejection.
is the respondent authorities, they did not place the matter. He was waiting on every DLC, he was expecting that his case would be placed, but it was not placed.
That is not a good job.
And they are the.
That is-
There is scheme of about 8
Financial
years road trip,
problem
and
is there.
there is no supporting documents regarding paragraph 10 road trip.
Because if they submit their application, it will be taken
that this is the subsequent application will be taken as the application and they will say that, this case is rejected on the ground
At
of late
least
submission of
if the
application.
year, if you don't know the date, also the year when you approach the authorities.
Not, I'll take some instructions from the petitioner, maybe some records are available.
On
He has not
request
published.
by Ms. S.P. Chowdhury, learned counsel for the petitioner. How much time?
1 week.
Just a matter of after 1 week, to enable her to receive instruction.
Item 14. May I please, your lordship? Lord, basically the challenge made in this petition is a, my lord, vitiated departmental proceeding which is proposed to be initiated, my lord, in violation of the, my lord, the prescribed provision of the rule, my lord, which is required to be followed. Lord, what the authority have done, my lord, they have initially issued a charge memo without, my lord, furnishing the list of documents, the statement of allegation basing on which the charges has been leveled. Nothing had been, my lord, communicated to me. Now, my lord, subsequently, my lord, on I have to say, my lord, on installment basis, they are sending some documents, my lord, by registered post in my home address. My lord. So therefore, my lord, I could not make the same, my lord, as a combined list of documents to prepare my defense. Now, my lord, the charges which has been leveled is arising out of a, my lord, writ petition and the order, my lord, passed by this honorable court. I beg to draw my lordship kind attention, my lord, to that order, starts at page 34, my lord. My lord, may kindly skip the first page, we start from the fact, a small order, my lord, 35. May I read, my lord? The petitioner is the third teacher in the subject English in the Lahorighat Senior Secondary School. By the order dated 4/2/2021, two teachers in English subject, namely so-and-so, had been provincialized. Although it is stated that Dilwar Hussain had died prior to the order of provincialization, we are not concerned with the said aspect for the purpose of this writ petition, and it is for the authorities to take their own call on the matter. It is considered by the learned counsel for the petitioner that on conjoint reading of section 317 and section 3111 of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017, in respect of secondary school, one teacher in every subject is entitled to be provincial. Section 319 again provides that in the event of enrollment of a student in a given subject is more than 80, a second post of the same subject would be available for provincialization. And in the event it is more than 150, a third post will be available for provincialization. So, my lord, it is the claim, my lord, this writ petition had in fact not been filed by the present petitioner, my lord. This petition was filed by the respondent number 4, my lord. Respondent number 5, my lord. Now, ultimately, this honorable court, my lord, by considering this, my lord, entire fact, my lord can find the relevant paragraph is at page 36, my lord, para 5. Accordingly, the District Scrutiny Committee of Moregaon District is directed to examine the service particulars of the petitioner as well as to arrive at its satisfaction as regards the number of students enrolled in the subject English in the Lahorighat Senior Secondary School. If the petitioner is otherwise entitled and the number of students is more than 150, appropriate reason order be passed as to whether the school concerned is entitled to a third post for the purpose of provincialization in the subject English. If yes, consequential benefit accordingly be provided to the petitioner. The requirement of passing a reason order be done with a period of 2 months from the date of receipt of a certified copy of this order. Let a copy of the information regarding so-and-so provided by so-and-so Education Department be kept on record. You know, this information regarding the enrollment has been provided by to my lordship and which is still on record. Now, you know, when this order has been presented before the District Scrutiny Committee, Moregaon, then the entire story has come up bioweapon, my lord, speaking order, my lord, may be pleased to find that order is at page 44, my lord. My lord, this is a long order. My lord can skip the few parts, my lord. I am reading from second paragraph. This is a vital order, my lord. That's why I am taking some time from my lordship, my lord. Whereas the Honorable Guwahati High Court in its order dated finalized the WPC number directing the District Scrutiny Committee Morigaon to examine the particulars of the petitioner as well as to arrive at his satisfaction as regard the number of students enrolled in the subject English in the so-and-so school. If the petitioner is otherwise entitled and the number of the student is more than 150, an appropriate reason order be passed as to whether the school concerned is entitled to a third post for the purpose of provincialization in the subject English. If yes, consequential benefit so and so, so and so. Whereas on receipt of the minutes of the District Scrutiny Committee as well as the other available records as received from the inspector of school so and so, it is observed that the petitioner so and so does not fulfill the criteria under section 20 of the Provincialization of the Services of the Teachers and Reorganization of the Educational Institution Act 2017 as amended in so and so. That is, must have rendered at least 6 years of continuous service as on 1/7/2017 from the date of joining in the venture educational institution, which must be on 31/12/2010 or prior to that, and accordingly the claim of the petitioner was rejected by this office order number dated 10/2025. Now, my lord can skip the few paragraphs. The my lord, petitioner did again file a contempt petition, my lord. That contempt petitions had also been considered, that they filed before the Honorable Guwahati High Court along with the copies of the attendance register from December 2010 to June 2014. Here is the problem, my lord. This teacher attendance register, my lord, had been first time had been bring into the record of this Honorable Court, my lord, from 2010 to 2014 by the that petitioner respondent number 5 herein, my lord. Now, as a result, what has happened, my lord? The director was, my lord, was not aware about the teacher attendance register. What has happened? The school was misplaced this, my lord, year's teacher attendance register. Therefore, the management committee of the school, my lord, has given and trusted the present petitioner to go for preparation of a, my lord, the exact duplicate copy of the original one and to certify the same, my lord, that this is the issue. It is not the sole decision of this, my lord, present rate petitioner who happens to be the academic in charge of the state school. My lord, maybe I would like to draw my lordship's kind attention to the resolution adopted by the management committee, which is at page 38, my lord. My lord, at page 39 is the relevant part. My lord, third resolution, it is decided in the meeting to convene a meeting having member of the earlier so and so that the greater interest given to the duty to certify a new attendance book where the teachers have signed. Fourth resolution is relevant, my lord, and I have also annexed the vernacular part also, my lord. And so therefore, my lord, the director who has leveled charges against me that the teacher attendance register, my lord, which I did certify, is a, my lord, my own as a, my lord, is my own decision, not as a collective decision of the management committee. Therefore, the entire allegation and the charges in the departmental proceeding, my lord, had been leveled against me as an academic in charge of the institution, which is in fact is not at all correct. My lord, though the departmental proceeding they have initiated after this order, my lord, may be pleased to find the charge memo, my lord, which I have also annexed. Is at, my lord, page 46, annexure 8. In exercise of the power conferred by the government notification number dated so and so, the undersigned is hereby to so cause under Rule 9 of so and so why the penalties should not be inflicted on me on the following charges based on the statement of allegation attached herewith. Whereas while you are serving as the academic in charge of so and so school, you have submitted fabricated and manipulated, my lord. This is a very serious allegation has been leveled against me. There is no fabrication and manipulation, my lord. The definition of fabrication and manipulation is something different. Now, my lord, as the teacher attendance register is not available, the management committee, I being the Milord academic in charge, has given me the authority to go ahead for certifying the state teacher attendance register. So now, Milord, this is the basic charge which has been leveled against me. So therefore, they are saying that you are charged with willful negligence and failure in discharging your official responsibility. There is no my willful, nothing is willful, Milord. It is, I am the duty bound to follow the instruction of the management committee also. Perhaps, Milord, this thing was required to be brought into the notice of the director, but that had not been done, Milord, being a provincialized institute. So, Milord, therefore now, for no fault for me, I have been, Milord, suspended from my duty as well by the order dated which I have just brought into my lordship's kind notice, and now a departmental proceeding has been initiated for no fault on me. A departmental proceeding, Milord, which is also void ab initio, because without the statement of allegation, without the, Milord, list of documents, nothing is complete, Milord. So therefore, I have also raised objection by a written representation, Milord, which my lord may be pleased to find is that, Milord, why, Milord,
When was this
registered post,
initiated?
my lord,
When was this show cause notice issued?
this charge memo, Milord. Yes, a charge memo dated, Milord, is on. Milord, unfortunately, the date has not been given in the charge memo, but I have received this on, Milord, from 1st of May 2025, then, Milord. Then I have, Milord.
But no, it's not a charge, it's a show cause.
No, no, Milord, kindly see. Although it has been written as a show cause, but it had been issued under the provision of the Rule 9. Now, if we go by the contents of the, Milord, this letter, I have to say, Milord, this is a clear and specific charges has been leveled. Had it been a show cause, Milord, then I could have responded. But now they have decided to impose me punishment. My lord, may kindly see that show cause under Rule 9 of so and so, why any of the penalties prescribed in clause 1 to 7 of Rule 7 of the aforesaid rule should not be inflicted on you. So show cause could not be, Milord, in this form, Milord. It could be a charge memo. So, Milord, although heading is charge memo, but the content is regarding a charge, Milord. They are going to impose me punishment. So in such a vitiated, Milord, charge memo, I cannot be compelled to participate, Milord. And that too for a fault, there is no fault on my part, Milord.
Have you given your written?
No, no, Milord, I could not, because why I could not, there is no document. Along with the charge memo, they have not furnished me any document. Milord, I have responded on 8/5/2025, page 50, annexure 9B.
Yes, coach.
Well, you actually kindly find the order that is challenged. Oh, page 44. The Lordship has already read it. And read one fourth paragraph. The fourth query. Page 44. Fourth paragraph, whereas on receipt of the information. So, this, whereas on receipt of the information, an inquiry was conducted by the undersigned, and the present academic in charge, that is the petitioner, as well as the office assistant, namely so-and-so, of so-and-so, were called for hearing in different dates to find out the actual fact. And during the course of hearing, both so-and-so have submitted their statement. Whereas Mohammed Faizur Rahman, PGT teacher and academic in charge of so-and-so school, submitted a statement on 19/3/2025, claiming to have submitted 8 attendance register of his institution before the inspector of school on 10/2/2025, and another newly constructed attendance register duly certified by him on backdated was submitted before the undersigned on 8/3/2025. Whereas no record regarding the attendance in respect of the petitioner of WPC number so-and-so for a period with effect from December 2010 to June 2014 was submitted at the time of
submission of the document for provincialization of the staff of the Laharigat Senior Secondary School and even after finalization of the WPC number 4409 of 2021. So, my lord, this order was passed after a hearing was conducted and he was duly given opportunity of being. And thereafter, my lord, this so cause was issued. Now, my lord, my learned friend submits that this with this so cause there is no statement of allegation. So the statement of allegation is page 54.
I have,
Which-
my lord,
Malak,
this
may I
statement-
just-
no, my allegation is that I have annexed this statement of allegation. It has been submitted after the charge memo, my lord. Installment basis, my lord. Today charge memo, tomorrow allegation.
And this statement of allegation at page 54, my lord, page 55, my lord, contains the list of documents, the list of witnesses. Now, my lord will kindly see what was his grievance in the representation, my lord, 8/5/2020, after he have received the. But it is nowhere said that the statement of allegation is not received. My lord will kindly see page 50. May I just read it? Your lordship will kindly see from the word starts, however. Fifth line from the top, bottom line. Page 50. This is the letter after he have received the the so-called notice. However, I humbly beg to state herein that there are further other
See,
relevant.
Rama, we are one. In your representation,
That is correct, my lord.
I'll just read it out.
My lord.
I've perused and gone through the statement of allegations.
Yes.
My lord.
Attached along with the aforesaid show.
Yes.
My lord.
That was his case.
That is the
No, my lord, his representation, my lord, is my response to the original charge memo. Whatever I have written here, I cannot deny. But my lord, it is a fact that in the original charge memo, the charges which has been leveled, my lordship is my lord may kindly appreciate, my lord, that when there is a no fault, because they are also silent regarding only my learned friend is on the technicality. That what is my grievance? My grievance in my repetition is that for an offense,
No, I'll come to that, my lord.
for an offense, my lord, which I have never committed, for how they can initiate a departmental proceeding against me, that to now, my lord, then in such type of cases, every principal in charge, my lord, when there is a fault or there's some irregularities in the provincialization, my lord,
We are not confined with every month.
what is there in your representation?
my lord.
Because earlier you said that the allegations, it's what we call the statement of allegations were not enclosed in the show
The
cause
list of
notice.
documents and the list of
My lord.
witnesses.
And, but then according to your representation, that was enclosed with the show cause.
My lord.
But
No,
then
my lord,
you wanted, read it, read
my
your,
lord, my lord, my lord, my
read
lord.
your, page 51, that is the original one.
Yes.
Yes. My lord, I have perused and gone through the statement of allegation attached along with the aforesaid so-called notice. I have covered, my lord, what they have done. Initially, my lord, they have issued this purported discharge memo, alleged to be so-called. Now, my lord, thereafter, I have received the statement of allegation by registered post separate. Then the list of documents separate.
Then why have you written attached?
No, attachment, my lord, ultimately it is the attachment, the charge memo will automatically get attached to that, my lord. My lord, I can prove,
Lordship will
my
kindly
lord, I
come to
can,
page 56 for a moment.
my lord, I can prove from my records, my lord, the registered post which they have sent to me. Partly, my lord. Now, how I can conjoin everything, although, my lord,
Page
yes, I
56.
admit, my lord, that this attached or word is something meaning is different. That I admit. But it does not mean, my lord, that my lord, statement made in the specifically made in my repetition is incorrect, my lord. I have make this statement on both people, my lord.
See, there are no other documents.
No, my lord, page 56, your lordship will kindly see.
Showing that you got the documents piecemeal.
No, I have stated in.
But then
repetition.
there's
It
only
is
one
not a
doc-
question
only
to
one
smile, my
document.
lord. It is a question of a service. As my learned
Page
friend is.
No, no,
56,
Wayan,
my lord,
Wayan,
my lord.
listen to me.
My lord,
There's nothing in this repetition
my lord.
to indicate that you have been receiving your documents piecemeal.
No, I have stated.
But then, no, you have statement in there,
My lord.
but there's no proof. The only thing is your representation,
No,
which
my-
you have
my-
annexed,
That is correct, my lord.
which clearly shows that the statement of election was attached to the show post notice, plus your statement as well as the statement of another person. But then what you have stated in your revision is that there are some more other documents which you require.
You want to
And
inspect.
You want to inspect this.
Those
So,
documents,
inspect
they
those
have not furnished to me.
We'll allow him to inspect. Madam. That's no problem.
No, no.
And
Those-
22nd is the date for hearing, my lord. 22nd is the date fixed for hearing. On that day, he can go and he can inspect it.
Tomorrow, that is.
Tomorrow.
I have not been informed. my lord.
How do you know it is
Well,
tomorrow?
Documents for documents inspection. my lord.
In their mobile, my lord, I can.
No, we'll
can come to know.
now my learned friend can inform his client that at 22, it is fixed for document inspection. He can go and.
I should approach, why this honorable court is required to be taken into, my lord, this person is required. They can communicate it, my lord, to the petitioner. And secondly, my lord, my another insertion, my lord, in my tomorrow.
26. We can put it on 23rd also, if it is inconvenient for the petitioner to come.
We take up at 2 o'clock. You finish copies of that to learned counsel to the petitioner.
This
Then we'll
My
take
lord,
up
my
at
another prayer is that, my lord, this departmental proceeding, they cannot initiate against only me. Because, my lord, it is a collective decision, whatever the allegations they are leveling, that, my lord, may examine, my lord.
that we'll see.
My lord.
But that perhaps is not a pleaded case.
At 2.
No, that is the pleaded case, my lord.
Lord, equal of time, next time. Lord, the metamer, he taken up at two.
Item 15.
At two, item 15, at two.
At 2. Then after Boyan's case.
Obliged.
Just 5 minutes.
May I please, Mr. My lord, this matter relates to, my lord, that the petitioners were initially appointed, my lord, as a graduate teachers in their erstwhile, my lord, upper primary school, my lord, before their amalgamation. My lord, I beg to draw my lordship's attention to the advertisement, my lord, by which we had been recruited, my lord, is at page 52. With a view to support, strengthen and improve the quality of elementary education in this. My lord has got it, my lord, at page 52. Elementary education in the state of Assam and in compliance with the so and so in pursuance of the government letter number and as per the provision of the Assam Elementary Education Provincialization Rules 1997 as amended in so and so. Online applications are invited in the prescribed format from all the eligible qualified candidates who are the citizens of India as defined in Article 20 of the Constitution of India for filling up of the following vacant posts of the teachers in provincialized lower primary and upper primary school under the Directorate of Elementary Education Assam as per the district-wise and category-wise breakup of posts shown below. So, my lord, these are the conditions and the qualification which has been prescribed, my lord, wherein we, my lord, tendered our, my lord, submitted our representations at page 53, serial number 2. You know. Assistant teacher for the upper primary, serial number 2, we are concerned, my lord. Assistant teachers for the upper primary school. My lord, may kindly note the qualification, essential qualification which they have prescribed is a graduate degree from the UGC recognized university and that qualified Ministry of Human Resource Development, so and so, Government of Assam, so and so. And my lord, may also note the pay band of rupees 5,200 to 20,200 as a grade pay has been earmarked. So responding to this advertisement, my lord, we did apply and accordingly we got selected and was also appointed. This series of appointment orders, my lord, I have annexed from page 56, my lord, annexed as free series of 28th of June 2013, my lord. Lord, I will not trouble my lordship with all the appointment orders, my lord. From page number 56 to page number, my lord, 69. Page number 69, my lord, all these are from page number 56 to 68, all these are appointment orders of the present petitioner. wherein their names are there is no dispute, my lord. Now subsequently, my lord, some of the petitioner has also been taken the mutual transfer at their own request, my lord, in the same category of school, that is from upper primary to the upper primary level schools of the same district, my lord. At page 69 is one of the such transfer order, my lord. Then, my lord, after this, my lord, order of transfer, my lord, then the provision of amalgamation has been come up, and the, my lord, the government, my lordship is well aware, my lord, that the under the Shiksha Kshetra scheme, my lord, the government has initiated a process for the amalgamation, and my lord, I have annexed the such amalgamation orders also, my lord. Starts at page 85, my lord. Annexure 5, my lord. Amalgamation of schools located in the same campus under the Shiksha Kshetra schemes for the amalgamation of schools. I am directed to say that the governor of Assam is pleased to amalgamate the following schools with the following for high school under the Shiksha Kshetra, a scheme for amalgamation of schools which are located on the same campus in pursuance of the government DM issued number so and so dated, subject to the condition that no additional posts are created and no additional financial implications will occur. So, my lord, there are series of amalgamation orders in respect of the petitioners, my lord. We have tried to annex the each and every one of the same. Now, I beg to draw my lordship's kind attention to, my lord, the scheme under which, my lord, we were amalgamated, my lord. It starts at page 102, annexure 6, my lord. My lord, may kindly turn to page number 104, my lord. First, clause 5, I beg to draw, my lord. Here, my lord, clause 5 says, in case of an LP or ME school is amalgamated with a high school or the higher secondary school, the assistant teacher and other staff of the LP or ME school shall be the employee of the amalgamated school, and their services shall be placed at the disposal of the secondary education department. The staff returns shall be fixed as per the existing norms for a high school and higher secondary school, and the excess teaching and non-teaching employees shall be posted elsewhere against any vacant post with the protection of their seniority of the earlier school. There shall not be any financial loss to any of the existing incumbent, and whatever emolument they are getting shall continue to receive even after amalgamation. So, my lord, this clause makes it very clear, my lord, clear that those incumbents, my lord, who were originally in the LP or MA school had been subsequently amalgamated to the high school, they will be anchored or placed under the secondary education rule in their appropriate cadre by keeping their seniority intact, my lord. So therefore, my lord, as we are, my lord, the inductment as a graduate teachers, my lord, as our basic and essential qualification has been shown to be a graduate degree holder, my lord. So therefore, another clause is vital, my lord, which is at page 106, clause 16, my lord. Clause 16, my lord, gradation list. Each of the teachers shall be the teacher of the higher school after amalgamation of merger, and their status will be revised. After amalgamation of merger, the gradation list of the school or district, as the case may be, has to be revised by incorporating the name of teachers against the higher schools in accordance with his/her qualification and status. He/she will get seniority as before, and his/her name has to be placed in the appropriate place in such a way that he does not lose his/her seniority. So, my lord, the gradation list is also required to be prepared in this manner after the amalgamation. Now, what has happened, my lord, in the district of, my lord, Sonitpur and Vishwanath, starts at page 108, annexure 7, my lord, the complete gradation list which has been published in the website, my lord, where from we could download the same. My lord, we have gone through the entire provisional as well as the final gradation list also there, my lord, wherein, my lord, our name is not there, my lord. Although some of the incumbents, my lord, whose initial date of appointment has been shown, below us, my lord, we were originally appointed in the year 2013, my lord. Even then, our name has not been placed in appropriate places. Now, as a result, my lord, what is going to happen, my lord, we are going to lose the benefit of our seniority as well as, my lord, the very purpose of creation of the gradation list or the is at the answering process of the promotion of the headmasters are going on. Now, my lord, we are not saying that we should be promoted immediately. If our seniority allows us, my lord, that we can be inducted or we can be interviewed or called upon, then it is a different aspect of the matter. But not finding the place in the gradation list, we were outrightly outside from the purview of the selection. I mean, another thing I beg to draw my lordship's attention, my lord, that the definition of the graduate teacher's name. I have, my lord, I am not troubling my lordship with the rule, my lord. I have quoted at page 22, paragraph 12, my lord. My lord. Page 12, paragraph 12, my lord. Graduate teacher means and includes the category of the assistant teacher, classical teacher of higher secondary or the senior secondary, erstwhile junior college or high madrasa or a high school, including the amalgamated higher secondary and the senior secondary and high school, for whose appointment the minimum qualification is graduate in arts, science, commerce from the recognized university, including the demonstrators of a provincialized higher secondary schools or a senior secondary school. Now, my lord, a plain reading of this definition, my lord, and our recruitment, my lord, if we go by the advertisement, if we, my lord, conjoin both the one, then we fit into this definition as a graduate teacher category. That apart, my lord, the revision of payroll has also been, my lord, revised time to time. My lord, maybe I have connected that part also, my lord. My lord, may be pleased to find at page 182. I beg to draw my lordship's attention to page 183, my lord. Huh? 182. Now, my lord, graduate teacher, here is page and 2. Graduate teacher, my lord may have found that 5,200 to 20,200, which we are receiving at this moment. And secondly, my lord, after this recommendation, the rule of revision of pay rule has also been amended by 4th of August 2018, my lord, wherein, my lord, we have been shown as a trained graduate teachers irrespective of the arts, science, and commerce, and we are getting, my lord, the same benefit 5,200 to 20,200, my lord, at page 184. Now, my lord, and another important letter had been circulated by the respondent number 1 is at page 185, annexure 13, my lord. Meeting held on, this is a letter issued by the Undersecretary to the Government of Assam Finance Department to the Senior Most Secretary Government of Assam, all administrative departments, so and so. Meeting held on under the chairmanship of the Honorable Chief Minister to the Soto Assam Karmasari Parishad. With reference to the subject cited above, I am directed to state that it was decided in the meeting that graduate scale of pay is to be given to all posts which requisite entry-level qualification is graduation. As such, you are kindly requested to furnish the list of posts under your administrative control for which the requisite entry-level qualification at the time of recruitment is graduation, but the pay scales attached to it is undergraduate scale. Further, it was also decided in the middle of my respectful submission before my lord is that to bring into notice of this letter is that, my lord, the government is also very conscious, my lord, that those persons whose entry-level qualification had been treated to be a graduate, they are entitled to the graduate scale of pay, though we are already been given. And so therefore, my lord, from conjoint reading of the entire provision of the rules, laws, and acts, my lord, it is very clear that we are a graduate teacher, so we are entitled under the rule 14 of the secondary rule 2018 to be considered for the purpose of promotion. Now, at the very threshold, my lord, the gradation list is the basic, is the foundation for the purpose of promotion, wherefrom, my lord, we have been negated, we have been ousted. That is our case, my lord, which is arbitrary and unreasonable. My lord,
Two districts.
my lord, Sonitpur and Vishwanath. And Vishwanath. No, not at all. Some other cases, my lord, has also come up, and my respected senior friend has, my lord, asked for the obtain the instruction, my lord. What is the real story at the district level?
Look, at this stage, I'll pray for issuance of notice, my lord, because the question which has been raised, my lord, that will require a determination. But we'll not finalize it, my lord, till next fifth. So,
Well. No, my lord, we have not.
one, the code of conduct.
4, 5, 6 to Punakur. So, madam,
4 to 4 type of six.
you can do. Let's 4 and 5.
1, 2, 3, and 6. my lord. If you want. The other matters you not to be fixing and of keep. If you pick for the file. Along with the
My lord, along with W16 number, let's take a 2409 of 2025. 2025. Till then, my lord, they will not finalize.
But to finalize of the here, my lord, it is final list has already been.
Final list has
Will
been
not act
prepared,
upon.
with that, they
Will
will
not
not
act
act upon.
Final list is
Yes, sir, yes.
Here,
I have annexed, my lord, it is. Copies
from
and
page 130.
page 130.
What? Page
Page
130.
130, my lord. Up to 130.
On the final
29/3/2025.
of the district of that.
Sonitpur. Shall not be acted upon. Highly obliged.
Appointment matter. Here the petitioner was recommended matter, page 27. Page 27. This is the paragraph minor, his serial number is at 5. Sri Avinash Daily. It's in, his name is included in the paragraph, my lord. That amongst them, the name of so and so. So his serial number is here, 5, my lord. Sri Avinash Mili. Son of Vinanda Mili, recommended for the post of lower primary.
Number 5.
Yes, my lord.
Page.
Page 27. His name is reflected in the paragraph, my lord, not in my lord, the list.
Serial number 28.
Okay. Yes. Oh, Bina,
Serial number 28, okay.
recommended, man.
Yeah.
And thereafter, my lord, his name was not placed before the SLC.
That's an order.
No, 40. No, but
It's okay. 1 to 3 and 6.
1,
3 and 6.
11. The other. That's
Application, madam, it was made in time, but date is not there, madam.
Oh, there's no preference teacher.
Yes, madam.
So, how? It was not. Okay. It is.
Nice.
The petitioner was the president of the School Management Development Committee project. He has raised certain representation complaint against the respondent number 4. Pursuant to which lordship, a letter was issued by the respondent number 2 to the respondent number 3 to pose an inquiry into the matter. Kindly peruse page 32, lordship. Annexure I, lordship. But the respondent number 3 is not acting on the matter. At least this notice paper. Because the inspector will put. Who appeared? Secondary. Secondary. 61. Peter for this lordship. Lordship. Is it construction for safety? Yeah. Please, third picture. Keyboard letter. What the Lordship. It's not. Our tradesman, instructor, I guess. Can I get any picture? Lordship. Oblige your lordship. For admission, item number.
Make please. Item number 17 is basically we are challenging the decision of the university not following the petition in the inter which was held for the post of assistant professor in folklore. Here, your lordship, the issue is basically very trivial issue. The petitioner's application was rejected only on a ground by the IQAC. There's a cell of IQAC of the university. It is rejected. In fact, as per the UGC, they do not have that. He is not being called for the interview, and then ultimately, without him being called for the interview, so basically, my case is up. So your lordship will kindly take up the advertisement. That is important is from the advertisement. The advertisement your lordship will find that pays wait 30 what will pays 37. Page 37 is the type copy will figure to the specific department. The issue was with several other departments, so I am bringing on only this department. It is your lordship, Department of Folklore, page 37. Department of Folklore, and your lordship, read first, 2348. 2348. Satyajit Das. Page 37. This is the advertisement. The advertisement has some other post also. So this is the type copy with regard to the particular post in which the petitioner has applied. So this is with regard to Department of Folklore, Assistant Professor. Your lordship, important is this specialization. Lordship will see the specialization is open, desirable master of music and equipment. This part is in. Your concept is folklore. We have applied for the folklore, and this is the desirable qualification, which is master of music and equipment. Now, what is happening? After this, your lord, it's an open post. It's an open post. Desirable is master of music and equivalent. So some person will have the master of music will be desirable to be appointed in this pact. So it's an open post. Otherwise, it's a no. So they have given the minimum essential qualification as UGC norms. So UGC norms will follow. Your lordship, the date of the advertisement will lordship will see there. This is also important because they have in their affidavit brought that on record. So I'll this is on 12/6/2018. Down below it has been. The date is 12/6/2018, and the desirable qualification is these 2 points are important. Rest, your lordship, the qualifications of the petitioner and all that I have already annexed, and that I'm not going to read because he's otherwise qualified, your lordship. And that your lordship will find at page 23. All the documents have been annexed. I'm just reading the bio, showing the biodata because here everything has been given in concise form. So page 23 and Annexure 2 is the biodata of the petitioner. Here your lordship, he has HSLC, which is second division. Then is SSLC, that is first division. BA in geography, second class. Then MA in cultural study in second class. MPhil in folklore, first class. Now, your lordship, he has also been awarded the PhD degree that I have given. PhD degree was awarded to him. That was in folklore. That is on 3rd March 2016. He is also a PhD. He is an MPhil. He is a MA in cultural studies, and he has done his PhD in folklore, MPhil in folklore. In fact, your lordship, there is no graduation or such in folklore study. So therefore, it is only MPhil and PhD which can be done in folklore. The petitioner has done that. So this is basically his qualification. And your lordship, page 24, D, serial number D, your lordship will see. Sorry, C. Now, he is also NAT qualified, UGC NAT qualified in folklore literature in 2008. He is also NAT qualified. And D, your lordship, extra qualification, master in music. So this is the desirable qualification which the petitioner has. That is masters of music, M Muse. So this is basically, your lordship, the overall scenario of what is the petitioner's qualification. And then, your lordship, his teaching experience is also there. He has been teaching in that particular department. First, he was teaching in the Department of Tourism and Travel, and then, your lordship, 2.5 years in the Department of Tourism and Travel in Prakriti College. Then, number 3, your lordship will see 10 years teaching experience as assistant professor in contractual basis at so-and-so at Pasim Guwahati Mahavidyalaya. Then these are, your lordship, his, I'm not going into all these, but this is he also has the experience as required. Now, your lordship, what has happened? I'll take your lordship directly to the affidavit filed by them. So in this case, your lordship, what has happened? Though he has applied, he was not called for it. And he did not even know when the interview was held, and they have selected, the selection was, when he later on went to the university to find, then he found that the already selection has been held and the selection committee has already selected the person. Then he came before this on court. And at that point of time, this court has issued notice, and the other person, the respondent number, private respondent, has also appeared there. Now, what has happened? The affidavit filed by the university, I'll take your lordship. The affidavit. Why he has not been called? They have given that. That your lordship find from page 41 on. I will read your lordship para 4. 2 paragraphs I'll read basically. 4. May I read it? May I read the paragraph 4? That with regard to the statement made in paragraph so and so, while putting the petitioner to the strictest proof thereof, the deponent respectfully begs to state that altogether 30 numbers of candidates submitted application for the post of assistant professor in the Department of Folklore Research, Guwahati University, with specialization open, desirable Master of Music and equivalent against advertised number. So, accordingly, as per said procedure, the applications were forwarded to the coordinated Internal Quality Assurance Cell, IQAC, Guwahati University, for screening of candidates suitable for the purpose of not merely of assessment of eligibility, but to maintain standard quality for recruitment. This was done to maintain a standard as per the decision of Guwahati University Authority, keeping in mind the relevant UGC regulations. In the instant case, the IQAC of Guwahati University forwarded its report after due scrutiny, having assisted by the experts concerned at the IQAC. It is stated that IQAC in its report shortlisted 16 numbers of candidates out of 30 numbers of candidates, so that said shortlisted candidates could be called for interview. While the writ petitioner, Dr. Secretary Das, was not shortlisted with remarks that he had weak academic career, also indicating the ground for rejection that he does not fulfill shortlisting criteria mandated by EC. Moreover, as per the advertisement so-and-so, the mere fulfillment of qualification will not entitle an applicant for inviting to interview, and consequently, the writ petitioner of the incident case was not called for the interview. So now if they have specifically stated, why have not? The question is that they have called 16 numbers of candidates out of 30. And I have not called because there is a remark in the remark column where it was stated that I have a weak academic career. Now, whether the IQAC have a authority to shortlist with who has a weak academic career or not, or what is the role of the IQAC? Basically, they have stated that it was done as per the UGC note. In this case, we have stated that since the advertisement was of 2018 and subsequently the UGC notification of 2018 has come. Therefore, it is covered by 2000. I'll come to that. So, Lordship will take up the next, my affidavit in reply that your Lordship will find that page, that will start from page 47. page 47. Is an affidavit in reply by the petitioner against the affidavit in opposition filed by the respondents 1, 2, 3, and 4. Lordship has got the affidavit in reply.
This activity is something supplied to Canada.
No, I'll give him it. This is not against him. It is against the university. And not now, no allegation against him at all. Just pointing out what they have stated in their affidavit with regard to weak academic career, which should not have been. That is what I'm trying to come. Your Lordship will kindly take up para 5 of it. I'm replying to the paragraph 4 that in the affidavit. Para 5, your Lordship, kindly. That with regard to the statements made in para 4 of the affidavit in opposition, the deponent begs to state that the respondent have not specified under what criteria 16 numbers of candidates out of 30 numbers of candidates have been shortlisted by IQAC of Guwahati University. The deponent states that the IQAC of Guwahati University cannot override the provisions of UGC Regulation 2018. Clause 3.1 indicates as follows. So I have quoted that. I'll read that. I'm not giving the regulation one after another, so I'm just reading. Direct recruitment to the post of assistant professor, professor, and associate professor, professor in university and colleges, and senior professor in universities shall be on the basis of merit through an all India advertisement followed by selection by a duly constituted selection committee as per the provisions made under the regulation. These provisions shall be incorporated in the statutes, ordinances of the university. The composition of such a committee shall be specified in these regulations. As such, the UGC regulations have categorically discarded any other mode of selection and recruitment apart from which have been formulated by the UGC. So the UGC is very specific. It says that the selection will be on the basis of the merit of each candidate, and it will be done by a selection committee itself. Apart from that, they have directed that each and every college university will incorporate these in their own statute or whatever ordinances they have. So that means that the UGC ordinance will be absolutely applicable to each and every university. And then you know, next, continuing, the IQAC of Guwahati University have to follow the UGC regulation mandated for the purpose of recruitment. Under the above circumstances, the application of the writ petitioner with remark weak academic career cannot be a ground from preventing the petitioner from appearing in the interview. It is a different fact altogether whether the petitioner is successful in the interview or not. The role of IQAC in Guwahati University should be put under scrutiny as it is not an authority to decide the career of the candidates. At best, the IQAC can scrutinize the applications to find out their eligibility as per the UGC regulation and whether the candidates have the requisite qualifications. Also, it can verify the documents and other necessary particulars. The IQAC cannot sit as an interview board and decide on the merits, demerits of the candidate. At best, the role of the IQAC is to shortlist the candidates for interview only, and it does not have any authority to give any remarks. Though the respondents have indicated that the petitioner does not fulfill shortlisting criteria mandated by EC, they have not indicated or enclosed any such criteria. As such, the petitioner is in total darkness of such criteria. So they have in their affidavit did not enclose anything. That is why I'm saying that. I have enclosed, I'll come to it. If there is any such criteria, the same should have been annexed in the affidavit. Further, as such criteria as indicated should have been within the framework of the UGC regulation. I'll not read the letter part because here I have given my requisite qualification that I am the NET, MPhil, and PhD, the continuing paragraph. And also, I am in Masters in Music, which is the desirable, Your Lordship, eligible. So, then Your Lordship rests. Now, that is the only issue which is to be looked in. Then they again file an affidavit. The affidavit again been filed by the respondents 1, 2, 3, and 4. The university again file another affidavit. Let me know. No, yes. They stated as an affidavit, but it is an additional affidavit. Here, your lordship, that your thing, I think it is starts from 88. 80. Here, your lordship will kindly take up at page 90. In fact, in these two cases, the second case has also been mentioned in this affidavit. I'll come to that later on. Page 90, paragraph 3. That with regard to the submissions made on 15/6/23 in the incident written on the context of affidavit filed in the incident petition, so Dr. Satyajit Rai, and in the another writ petition, number so that is the other writ, the next slide. This humble deponent begs to state, while reiterating these statements made in the affidavit as filed by the Guwahati University, that as regard writ petitioner in WPC number, the advertisement was published on 12/6/2018 with the last date of receipt of application being 30/6/2018. Annexes 3 to the writ petition may be referred to. While the UGC regulation of 2010 was in force, whereas the UGC regulation of 2018 has come into effect subsequent on 18/7/2018. Annex to so and so, which regulation of 2018 have been afterwards adopted by the Guwahati University Authority in its EC meeting held on 25/1/2020. So they want to say that I have mentioned about UGC regulation 2018. Then they said that that is not applicable in this case because that was adopted by the Guwahati University later on, and it was in 2020, and therefore the earlier regulation of 2010 is applicable. So that is their state. Then they have in the I'm not reading 2 because it's the other matter. 3 all. The recommendations as incorporated in the minutes of the meeting held on 22/11/2018 in connection with shortlisting criteria required for recruitment of assistant professor so and so affidavit in reply number 20 do not have any retrospective effect, and as such not at all relevant to the selection process initiated through the advertisement dated 12/6/2018 as regard the writ petitioner. Unlike that of the writ petitioner, further at the time of state advertisement dated so and so, the EC resolution number so and so adopted in its meeting held on so and so was applicable as regards the selection process in tune with the UGC regulation 2010. So they are saying that it is on UGC regulation 2010. And they have stated that they crave liberty to provide the same before this on to court. Now, your lordship, against this, I have filed a reply. That is actually in page 94. In page 94, your lordship has got the reply to this affidavit. Here I have annexed those documents. So they have not produced, I have annexed those. That your lordship will find at page 100. I have annexed the document, but they have referred. This is the 22/11/2018 document they have referred to in their paragraph. In the affidavit in opposition, additional affidavit in opposition, they have indicated that particular date at para 3, at page 91, Roman 3, they have indicated recommendation as incorporated minutes of the meeting dated 22/11/2018 that I have annexed now. That annex, your lordship will find that at annexure at page 100. Your lordship will see what is that particular meeting. The first meeting of the committee for finalizing the following matters was held on page 100, 22/11/2018 in the VC conference room at 3 p.m. Number 1, shortlisting criteria for recruitment of assistant profs. CAS application format as per UGC regulation 2018. Application format for direct recruitment as per UGC regulations 2018. IQAC scorecard as per UGC regulation 2018. Guidelines for so and so. Now, your lordship, they in that meeting, They refer to 2018. They are saying at that point of time, 2010 was in force. But in fact, in that, because this was done after the advertisement, that is in 2006. This has come up in 2211, sorry, 2211, 2018 advertisement was of 2018 June. This is November. So they have in November decided that all the shortlisting criteria will be as per 2018 UGC regulation. And all the shortlisting criteria and appointment has come up subsequent to this. It is not that it was done at that point of time prior to the appointment, the selection, everything has held after. Now, Your Lordship, what they have stated in the minutes of the meeting, I'll read. The committee recommended the shortlisting for recruitment of assistant professor to be based on a score of 100 distributed across 9 parameters. The committee recommended the content and format of score sheet as indicated in Annexure 1. The committee recommended that the maximum number of candidates to be shortlisted for interview be 10. So this is important. The shortlisting of 10 applicants will be done on the basis of the score on the score sheet. Candidates with score below 50 as per score sheet will not be called for the interview. The committee recommended that a committee be constituted to review the internal journal of birth. This is not. Now what they have stated, basically there will be a total marks of 100 score and the shortlisting will be done. Shortlisting is that not by the Your Lordship, the selection committee. It is a shortlisting before the selection. So this shortlisting will be done on the basis of this 100 marks, and persons beyond above 50 will only call for the interview. And it will be the number of, if there is one post, 10% will be called for. This was a decision. Now they in their affidavit has already stated they have called 16. Under what circumstances, under which law they have stated that they have not. So they are not following their own. This is number 1. Now Your Lordship will see the next page, 101. This is the score sheet. This is the score sheet. They have stated that in this score sheet, how they will give the numbers wherein the total has to be 100. Who have picked that document?
One is mine meter. But
We'll complete this, then what you can take the second method.
can it be bifurcated in parts? Yes, but tomorrow. My learning fund is not there.
No, that is not against the anyway. I'll give. It's not against, nothing against. I'll give it, even then I'll give it.
Maybe, but it's not with me, right? Really has to the method. It takes some time. Regarding the timing, my understanding has referring the method after EPC promulgation of EPC.
Okay, that. Lordship, in that, then your Lordship make it, since I have already argued this, your Lordship can keep it as part of and pick it on. I am not with it.
On 12 June,
बहुत different, yeah.
then 5.
No, let it be next week, any your Lordship, because otherwise unnecessarily keeping it for so long.
But why?
I think it.
On 28.
28.
27. No, let it be 29. 20.
Not 29, no, on 28.
28 is good for us.
What are you difficulty? 20 what? 28 minutes Wednesday.
As a part of.
What?
Much.
Dear, I think I'm not feeling well. I have got an item 67 in the supplementary list. That is the last one item. And that only to, is an impending petition I have filed, only to issue the notice. Implementing petition. That's two or my lord.
You want to implement who?
Implement principal that day on hearing my lord, your lordship directed fix it to them, my lord. Medical leave, principal, my.
Then this is some other day. Yeah, now it's
It
if you want to.
will take 1 or 2 minutes, my lord, your lordship can take at 2 o'clock.
Or it come.
Now also your lordship can take my particular meeting. Okay, my lord, the day after the Friday. Habla. Falta খালি কথা দিতে হবে। নাহলে আবার সাপ্লিমেন্টটা দেয় এবার আরো
Yes, 31 and 32. My lord, my senior is out of town. So
Who's your senior?
Dr. Ankit Todi,
Yes, so what do you want?
basic 2 weeks time.
Only question on behalf of Dr. Ankit.
I'm for the respondent number. Let me repeat.
So please let me talk to the witness. Give a date of the 2 weeks. Let me make it quick.
And being item number 14. As per my instruction of my lord, on one Tarif Ahmed had received this letter on 20th on behalf of the petition. And this is in response to that 8-5 letter, case 50.
Lord, I have also taken the inspection method from the petitioner. Petitioner himself has not received any such type of notice yet. But as I have come to know, Miller, now I can convey regarding this over WhatsApp or any more, Miller. But Miller, my case is in a very, Miller, I know.
See,
that-
I'm making my point very clear.
My lord.
I'm not staying the department.
No, but no coercive action they may take up.
But no final orders will be passed. without
Fine.
the votes.
Yes, sir. That can be, that's.
So if you want notice to go, I'll issue notice, you can file your
Fine.
affidavit. We have no consequence. No issue notice. Mr. B. Kaushik, standing counsel. Secretary,
Second grade.
appeals for the respondents, 1, 2, and 3.
1, 2, and 3.
Extra copies. Additional reports that also this are just on the respondents. 4, 5, and 6. It's still possible. Within 1 week. Respondents are able to. Start. It's up to 4 weeks. But the respondents are permitted to proceed with the disciplinary process against the each. However, no final order shall be passed.
And the petitioner will cooperate.
No, that is up.
But your lordship will record that because
No, no,
your lordship is subjecting the orders.
And the shall not be cooperate with the. No, not the I have to proceed with the department. However, no final order shall be passed without.
Your lordship will indicate that because your lordship is restraining us from passing any order without the leave of the court. He may delay it, madam. In my respectful submission,
You can come before.
in my respectful submission, madam, he has challenged the so-called one. In my respectful submission, the charge that has been framed, it's a preliminary, it's a very premature one, my lord. Your lordship under 226 may not would like
Shall
to.
also cooperate with regard to the discipline.
My lord.
Obliged.
In this repetition, the disciplinary proceeding is assailed. My lord, there is a checkered history, but I'll be very brief, my lord. I'll give a little background, my lord. The petitioner for lordship is a professor of Guwahati University. He was appointed as a registrar in Procedural University, and he joined there on VN for a period of 2 years. During that period, my lord, there was some allegation of corruption against him, and he was placed under suspension, and eventually he was reverted back to the university, Guwahati University. In Guwahati University, my lord, he joined as a professor, and immediately thereafter he was placed under suspension, and the my lord, proceeding is initiated. Now, my lord, since my lord, I am praying for an interim order, my lord, I'll take your lordship only to my lord 2 orders for your lordship perusal, which will satisfy that, my lord, this is a political inquiry, and my lord, the decision has already been taken before I, my lord, respond to the inquiry report. Your lordship may kindly come to page 80, my lord. Page 80 is the page 81, my lord. Sorry, page 82. My lord, the inquiry report, I'll read, my lord, only 2 sentences. Your lordship will find that at page 97. Let us not go into the, my lord, details of his discussion. His, my lord, conclusion, your lordship finds that page 97. Yes. Down below, your lordship will find, my lord, conclusion. As your lordship conclusion.
Correct. Recommendations.
Before that, my lord, conclusion. No, in the same page, 1 sentence before that, my lord, conclusion.
Okay, yes.
Conclusion. The charge of misconduct brought out against the charged officer is proved beyond any reasonable doubt. Then, my lord, recommendation. As the charges of misconduct against charged officer Dr. Gurprasad Khatria has been conclusively proved beyond any reasonable doubt, I recommend his dismissal from service pursuant to clause 46 of the Guwahati University Employees Service Condition, Conduct and Appeal Rules 1970. Now, my lord, I pause here for a while. My lord, the inquiry officer is a, my lord, retired IPS officer. Your lordship will find that down below, my lord, he has signed IPS retired. He is the inquiry officer, and he has conducted the entire matter in a manner as if it is a criminal case. A criminal case is pending against him, my lord. That is a separate issue. A parallel proceeding on the same charges is, my lord, there. Now, if your lordship kindly recalls the provision of Rule 9 of the Assam Service Disciplinary Appeal Rules, the power and jurisdiction of the, my lord, inquiry officer is to give his finding on the charges, whether the charges have been proved or not. Now, here, my lord, he says that charges are proved, and he also recommends, my lord, dismissal from service. This is, my lord, beyond his jurisdiction. Then your lordship may kindly come to page 80, my lord.
80.
80. He has forwarded this, my lord, inquiry report, and the registrar of the university has communicated this letter at page 80, my lord, 13/5/2025. May I read it, my lord? Forwarding of inquiry officer's report for your response. This is to inform you that as per resolution number such and such of the Executive Council is the, my lord, disciplinary authority. Guwahati University adopted in its meeting held on 21/3/2025 the report of the inquiry officer in connection with the departmental proceedings drawn against you has been accepted by the council. Accordingly, as per the said resolution, the report of the inquiry officer is ever forwarded to you. Now, my lord, my submission with your lordship is that the inquiry officer's report has already been accepted by the, my lord, the disciplinary authority. Therefore, whatever, my lord, the so-called notice they have issued to me, my lord, inquiry report, and asking for the, my lord, the response to that,
That is only a mere, my lord, empty formality. And the decision has already been taken. That cannot be done under the, my lord, Assam Service Discipline and Appeal Rule. If your lordship kindly comes to the, my lord, rule, the proceeding is initiated under these rules, my lord. There are other questions, my lord, I am not urging at this point because, my lord, there was a direction of this honorable court that, my lord, some of the, my lord, the witnesses were examined behind my back in my absence, and I was directed to be given the opportunity to cross-examine them. That was also not given, my lord. It was proceeded in, my lord, such a, my lord, such a manner that, my lord, I did not get that opportunity in spite of the, my lord, this honorable court's observation. If your lordship kindly comes to Rule 9. Rule 9 is the, my lord, the disciplinary authority shall, if it is not inquiring authority, consider the records of the inquiry and record is finding on its charge. Now, my lord, here, the disciplinary authority is not the inquiring authority. Inquiry has been given to, my lord, retired IPS officer. Then your lordship may kindly come to 9.1. Disciplinary authority shall, if it is not the inquiry, so, my lord, it was contacted by another. Then, my lord, Rule 2. Then, my lord, your lordship may, my lord, after that 42nd amendment, my lord, there are decisions of the honorable court that, my lord, the inquiry officer has to give its report. My lord, to the inquiring authority, to the, my lord, delinquent, and that, my lord, delinquent will file his report, and thereafter only, my lord, the disciplinary authority have only, my, the two documents. One is the inquiry officer's report, one is the, my lord, representation against the report by the, my lord, delinquent. That was, my lord, settled by, my lord, settled out decisions of the honorable court. One decision, my lord, of this honorable court, a coordinate bench, my lord, that has discussed all the, my lord, earlier cases, more particularly, my lord, Ramzan Khan case and, my lord, PCI case. Now, here is a case, my lord, where the inquiring authority has already, my lord, recommended the punishment, penalty of, my lord, dismissal of service, which has been accepted. Therefore, my lord, this cannot be. This is, my lord, not heard of in service jurisprudence. Your lordship kindly comes to paragraph 7 of this, my lord, judgment of this honorable court of a coordinate bench. One aspect of procedure adopted by disciplinary authority in issuing the second show cause notice, the learned counsel for the petitioner has submitted that such second show cause notice has become a mere formality inasmuch as the delinquent officer was deprived of a fair opportunity to make an endeavor to convince the disciplinary authority to take a view other than the views expressed by the inquiry officer holding the delinquent to be guilty of the charges. And by referring to the notice dated so and so, it is submitted that the disciplinary authority had agreed with the view and had also come to a finding that the allegations were found true. In such circumstances, the scope of submitting a written representation was absolutely obliterated, as the disciplinary authority had already made up its mind on the establishment of the guilt. In support of this submission, the learned counsel has, my lord, these two decisions, Ramzan Khan and ECI. Then, my lord, paragraph 9, your lordship will kindly read. I will not take your lordship time much, my lord. In the case of Muhammad Ramzan Khan, the Honorable Supreme Court was explaining the position after the 42nd Amendment of the Constitution of India, by which the requirement of a show cause notice on the proposed penalty was done away with. It has been held that though the aspect of proposed penalty is not required to be notified prior to imposition of the same, the requirement of forwarding the views of the inquiry officer in case such inquiry is done by an officer other than the disciplinary authority would still be the mandatory requirement. The aforesaid position has been clarified by a later decision in case of B. Karunakar by holding that the proposition laid down in the case of Muhammad Ramzan Khan would be prospective in nature from the date of presentation. So, my lord, this is my right that, my lord, I file a representation against the, my lord, inquiry officer's report, and thereafter only, my lord, the disciplinary authority applies its mind. Here is a case, my lord. The inquiry officer has gone beyond his jurisdiction to, my lord, penalize me, and that has already been accepted by the authority. Your lord, you could remember, my lord, that case, that is KV, my lord, I have placed many cases on this. Therefore, my lord, my prayer would be, my lord, let them respond.
There are other points I am not arguing today, my lord. Let them respond and my lord, let them not proceed with the, my lord, the disciplinary proceeding till they, my lord, give their response. The inquiry, my lord, there is a list I have given, my lord, the way they have examined the witnesses.
When was this inquiry report? 13/2.
When was, my lord? I didn't get your.
The inquiry report submitted
Inquiry report has been submitted on, my lord.
13/2.
That I don't know, but it was communicated by that page 80 or
Page 82.
82 is, yes, ma'am. 80 is the order communicating me. Then, my lord, it was communicated on 13th of May, my lord. I was directed to respond within a period of 7 days. I asked for time, my lord. This is 82, my lord, date of submission 13/2/2025. But I was communicated only on 13.
Page 82, my lord, the date of submission of finding 13/2.
Okay.
My lord,
My lord, I have given a chart, my lord, to show that, my lord, my lord, the earlier order, my lord, chart, I have, my lord, I have approached this honorable court, my lord, saying that, my lord, there is a criminal proceeding pending in respect to the same charges. If your lordship kindly goes to the charge, my lord, only there are two charges. That charge your lordship will get at page 34, because that relates to, my lord, that, my lord, the criminal case again, my. Memorandum of charge your lordship finds at page 20, my lord, 34, dated 23/10/2024. And there are, my lord, two articles of charge at page 36. First charge is the Dr. So during his service tenure on Lien from the Guwahati University at Bhattadev University, Bagali, as his registrar on probation, was arrested on 6/8/2022 by the Assam police personnel in connection with allegation of acceptance of bribe money in SCT case number 20. Under section 7 of the Prevention of Corruption Act, investigation whereof is still going on. And Dr. Guru Prasad Patanir, after having detained in custody for more than 1 month, is presently under bail with certain directions as per the order dated 8/9/2022 of the Special Judge Assam. This constitutes a violation of Rule 4. So, my lord, it is directly connected with the criminal case. The second article is also, my lord, somewhat same. Dr. Guru Prasad Patanir, during his service tenure on Lien at Bhattadev University, as its register on probation, was suspended by this order dated so as issued by Vice Chancellor. This constitutes violation of rule. These are the two charges, ma'am. And this honorable court, my lord, in its earlier order, I came, my lord, before this honorable court saying that, my lord, the two proceedings cannot go together since the charges are same. Your lordship may kindly come to page 77, my lord, that is the operative part of this honorable court in the earlier proceeding. Page 77, my lord. Yes. My lord, in the first paragraph, last 4 sentences, that the above being said, in the event the petitioner has not been able to cross-examine the 3 witnesses on 16/1/2025, the IO should consider giving an opportunity to the petitioner to cross-examine the witnesses in the departmental proceeding. That was also not given, my lord. I have shown the documents to show that I asked, and my lord did it. Therefore, my prayer at this stage, my lord, let them respond until that time, my lord, your lordship will ask them to, my lord, keep the DP under.
Yeah, forgot.
Milord. Milord, the university stand in this petition is that the entire writ petition is to be dismissed in limine with fine. Since the conduct of the writ petition and the number of cases keep high before this honorable court, I take your lordship straight to page 77. Earlier writ petition.
That
The
was on a
relevant-
different ground. He wanted to engage a legal practitioner.
Milord. In that case, Milord, that petition was disposed of
Dismissed.
in favor of the. Now, can you turn to page 80?
Page?
80, 80.
Who is the order appointing the inquiry officer?
You know, that was settled in the earlier round of litigation.
We have never been communicated with any order that so-and-so has been appointed as inquiry officer, but that has been informed to us. Accordingly, my lord,
He
we
took
appear
part
to
in
the-
the
that will be a part of the discipline, my lord, fair record.
that from the first round is over when the dishonorable court has, you know, passed the order, page 77 in favor of the court. Now page 80. Merit. Forwarding of inquiry officer's report for your response. This is to inform you that as per resolution number so and so of the Executive Council Guwahati University adopted in its meeting held on 21/3/2025, the report of the inquiry officer in connection with the departmental proceeding drawn against you has been accepted by the council. Accordingly, as per the said resolution of the Executive Council, the report of the inquiry officer is hereby forwarded to you for your response. It is important, this sentence. That as per the resolution of the Executive Council, report of the inquiry officer is hereby forwarded to you for your response. So, my lord, no punishment has yet been made.
You have already accepted the inquiry.
No, my lord, it
report.
is that word accepted. And this line,
Why do you want to read this order? This is against you.
my lord, it is not against the university. My lord.
This is very much
That,
against.
that,
When who is the disciplinary authority?
the
Executive Council.
The
Executive Council has accepted the inquiry report.
my lord,
Correct.
my lord, that accepted means, my lord, received. My lord. My lord, it is
No,
not,
no, don't-
if it is accepted, then my lord, the punishment would be imposed. That second stage.
What is
on
the
top,
point of issuing a
Milord.
notice to the petitioner
my lord,
to give his response
my lord.
when they've already accepted the report?
That is why, my
It's
lord,
only an empty
should be-
formality.
it should be read together, my lord, and I will place the
No, no, you
judgment.
file your affidavit. We'll
My lord,
consider
I
it.
will, my lord, place the judgments, my lord, in this regard. After 42nd amendment of 1976, entire scenario has been changed.
That is changed.
So, my
So
lord,
far, the punishment that is required
And
to
the-
impose, you need not give the notice to the petitioner with regard to the quantum of punishment that you intend to
Milord.
impose. to the
so, my
petitioner.
lord, this letter is for responding against the inquiry report. One opportunity has been given by the Executive Council. My lord, if I come to the Supreme Court's judgment, my lord, I'll be very brief. my lord. This is managing
You
director,
place it in the next round after you file it.
my lord, since my lord, it's a very, my lord, vital aspects of the entire matter. So, my lord, my lord,
Okay, sure.
I'll rely on only paragraph 28 of this Constitution bench judgment. Managing Director ISIL Hyderabad versus B. Kornakar, para 28, 1993, 4 SCC 727. Para 20. Page 755. The position in law can also be looked at from a slightly different angle. Article 311(2) says that the employee shall be given a reasonable opportunity of being heard in respect of the charges against him. The findings on the charges given by a third person like the inquiry officer, particularly when they are not borne out by the evidence or are arrived at by overlooking the evidence or misconstruing it, could themselves constitute new unwarranted imputation. What is further, when the proviso to the said article states that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation. It in effect accept two successive stages of differing scope. It is important. Two successive stages. Since the penalty is to be proposed after the inquiry, which inquiry in effect is to be carried out by the disciplinary authority, the inquiry officer being only his delegate appointed to hold the inquiry and to assist him. The employee's reply to the inquiry officer's report and consideration of such reply by the disciplinary authority also constitute an integral part of the inquiry. The second stage follows the inquiry, so carried out, and it consists of the issuance of the notice to show cause against the proposed penalty and of considering the reply to the notice and deciding upon the penalty.
What is dispensed with is the opportunity of making representation on the penalty proposed and not of opportunity of making representation on the report of the inquiry officer. This is, my lord, vitally important in the present proceeding. Not of opportunity of making representation on the report of inquiry officer. The latter right was always there. But before the 42nd Amendment of the Constitution, the point of time at which it was to be exercised had to defer till the second stage, namely the stage of considering the penalty. Till that time, the conclusion that the disciplinary authority might have arrived at, both with regard to the guilt of the employee and the penalty to be imposed, were only tentative. All that has happened after 42nd Amendment of the Constitution is to advance the point of time at which the representation of the employee against the inquiry officer's report would be considered. Now, the disciplinary authority has to consider the representation of the employee against the report before it arrives at its conclusion with regard to his guilt or innocence of the charge. So, Miller, to arrive at the guilt or innocence,
This is totally against you. This is
No,
in
Miller.
favor of the petitioner.
that report has been accepted, received, Miller. Though the word used was accepted, it will have been read together with the second
Going
sentence.
to
Miller.
go
Otherwise,
only on the basis of materials available of report. And this report, this notice of the register University 13/5/2025 clearly indicates that the Executive Council has accepted the report of the inquiry officer.
then, Miller, no occasion
Then there
arises,
is no
Miller,
point of giving this
to-
notice.
if the entire report with the recommendation has been accepted by the Executive Council, then that second sentence, why he has been, Miller, directed to respond the inquiry officer's
That
report.
is what we are asking you.
That is why
You have to
Miller,
answer that, not this.
Miller, the entire sentence to be read together with the second sentence.
All right.
First, Miller, that response
Third,
will be
Mr. MP
Miller,
Chowdhury.
Miller, and the conduct, Miller. This was the factual, Miller, legal background of after 42nd Amendment. Now, kindly,
You are trying to explain what is accept and what is
no,
it?
Miller, not on that, Miller.
Then what do you
The
want?
conduct of the employee concern, Miller.
Let the court pass orders.
Miller,
You can go and appeal.
he praised for extending the time to file response. And he has been given time for 5 days, Miller, additional time. In spite of that, Miller, what the Supreme Court says, Miller, that conduct, Miller, that is not acceptable to this honorable court. Para 29. It starts from page 21, Miller. He has been given 7 days time. Then he praised the last days, Miller, for another 7 days time. Day before yesterday, he has been given 5 days time, but he came up before this honorable court with it. The conduct, Miller. Para 21. Captain M. Paul Anthony also deserves to be noticed. This court therein held that the departmental proceedings need to be stayed during pendency of the criminal case, save and except for cause and reason. The court summarized its findings as under. Departmental proceedings and proceedings in a criminal case can proceed simultaneously, as there is no bar in their being conducted simultaneously, though separately. Now we can, Miller, skip the other paragraph 29. The last page. Furthermore, the discretionary jurisdiction under Article 226 of the Constitution of India should be exercised keeping in view the conduct of the parties. It is very, very important, the conduct of the parties. The respondents made a representation that in the event the order of suspension is revoked, they would cooperate with the inquiry officer. They kept on filing applications for extension of time. You know, the last page indicates that he prays for extension of time, which were allowed. He has been allowed 5 days additional time. They took benefit thereof. Without, however, filing so cause, they moved the High Court. Here, Miller, taking the benefit of the extension of time, Miller, he moved this Honorable High Court. Furthermore, before the inquiry officer also, as noticed herein before, although they had appointed the defense counsel, did not cross-examine the witnesses examined on behalf of the management. A large number of witnesses had already been examined on behalf of the appellants. The disciplinary proceedings, as we have noticed herein before, have proceeded to a great extent. In such a situation, we are of the firm view, it is important, Milord. In such a situation, we are of the firm view that the discretionary jurisdiction should not have been exercised in favor of the respondent 1 to 4 by the High Court. For the reasons above mentioned, the impugned judgment cannot be sustained, which is hereby set aside. Appeal is accordingly allowed. We would, however, like to observe that in the event any prayer is made by the respondents to cross-examine the witnesses examined on behalf of the appellant, the inquiry officer may consider the same in accordance with law, keeping in view the conduct of the respondents. It is important, Milord. Fine has been imposed, Milord. Keeping in view the conduct of the respondents, they are directed to bear the cost of the appellants both before the High Court as also before us. Counsel's fee assessed at ₹25. So, Milord, the last page indicates that he prays before the Executive Council for extension of time to respond properly. He has been granted extension of time day before yesterday. 5 additional days. May I please, Milord? Itu লৈ যোৱা কথাই পাতিম। It would be read together with the last page of the writ petition. First, the last page of the writ petition. Then the conduct of the writ petition would be revealed. It would be read together with the last page. Page 99. Totally unacceptable behavior. To the Register, Guwahati University, I have been in receipt of the inquiry report so-and-so, pursuant to which I was granted 7 days time to go through the same and prepare my response. In this regard, it is important. I humbly beg to state that the inquiry report is voluminous, and for me to prepare an effective reply, in as much as my service career is at stake, I implore your good self to kindly grant me an additional 7 days time. I shall be eternally grateful for your consideration in this regard. It was dated 16/5/25. Now, Milord, the next, our extension of time, Milord. It was issued 19/5/2025, before the expiry of that 7 days time, to the writ petitioner, with reference to your letter dated so-and-so, wherein you requested an extension of 7 days for submission of your response to our above referred communication dated so-and-so. This is to inform you that Guwahati University has accorded an extension of 5 additional days from the original due date for submission of the said response. It was dated 19/5/2025, day before yesterday. You are therefore requested to ensure that your response is submitted within this extended timeline. No further extension shall be entertained. This is issued with the approval of the Honorable Vice Chancellor. So, Milord, he would have enough opportunity to agitate before the Executive Council, Milord, all the grounds that have been, Milord, incorporated in the writ petition. But without, Milord, that penalty imposed by the disciplinary authority, this Executive Council, Milord. Milord, this writ petition, Milord, in the midst of the proceeding, Milord, and the inquiry proceeding, Milord, it's not acceptable in the eyes of law. And this State Bank of Patiala and SK Sharma's, Milord, judgment, Milord, I also referred at that, only at that. It will be that prejudice aspect. I'll refer only para 28. Milord, I will skip para 28. The first part I will skip, Milord. It is not relevant, Milord. Presentum B, Milord. Indeed, may I read, Milord? page 386. Indeed, there may be situations where observance of the requirement of prior notice hearing may
What's the?
President B. B for Bombay.
Yeah,
Indeed.
okay.
It starts from indeed. Indeed, there may be situations where observance of the requirement of prior notice or hearing may defeat the very proceeding, which may result in grave prejudice to public interest. It is for this reason that the rule of post-decisional hearing as a sufficient compliance with natural justice was evolved in some of the cases. Liberty Oil Mills versus Union of India, that is constitutional bench judgment. So post-decisional hearing is important. Decision has not been taken as yet regarding that imposing of punishment. Otherwise, that later, page 80, it would have revealed that we have accepted the dismissal recommendation and no opportunity would be given, and no extension of time would be given, So it would have to be, first sentence and second sentence. Both would have to be read together. Now the next line, Liberty Oil Mills versus Union of India. There may also be cases where the public interest or the interest of the security of state or other similar consideration may make it inadvisable to observe the rule of odi alteram partem altogether, as in case of situations contemplated by so-and-so, or to disclose the material on which a particular action is being taken. There may indeed be any number of varying situations which it is not possible for anyone to foresee. In our respectful opinion, the principles emerging from the decided cases can be stated in the following terms in relation to the disciplinary orders and inquiries. It is important. A distinction ought to be made between violation of the principle of natural justice, odi alteram partem, as such, and violation of a facet of the said principle. In other words, distinction is between no notice, under quotation, no hearing, under quotation, and no adequate hearing, under quotation, or to put it in different words, no opportunity and no adequate opportunity. To illustrate, take a case where the person is dismissed from service without hearing him altogether, as in Rees versus Baldwin. It would be a case falling under the first category, and the order of dismissal would be invalid or void, if one chooses to use that expression. But where the person is dismissed from service, say, without supplying him a copy of the inquiry officer's report, that managing director's case, constitution bench judgment, or without affording him a due opportunity of cross-examining a witness, KL Tripathi, it would be a case falling in the latter category. Violation of a facet of the said rule of natural justice, in which case the validity of the order has to be tested on the touchstone of prejudice. That is, whether all in all the person concerned did or did not have a fair hearing. It would not be correct in the light of the above decisions to say that for any and every violation of a facet of natural justice or of a rule incorporating such facet, the order passed is altogether void and ought to be set aside. Next, 4 lines. Without further inquiry, in our opinion, the approach and test adopted in B. Karunakar, that judgment, should govern all cases where the complaint is not that there was no hearing, no notice, no opportunity, and no hearing, but one of not affording a proper hearing, that is adequate or a full hearing, or of a violation of a procedural rule or requirement governing the inquiry. The complaint should be examined on the touchstone of prejudice as aforesaid. So, my lord, in view of this, he will respond within that extended 5 days period. That would be considered by the Executive Council. Then, if he still agrees, then he could come with an appeal to the superior authority, that is the Chancellor, or come to this Honorable High Court under Article 15. Otherwise, his conduct, his prayer petition, page 99, the last page, for extension of time, he is using 2 platforms. One, the Executive Council, another this Honorable High Court. First, he is praying for extension of time. He has been granted. And in the meantime, he has come to this Honorable Court for second time, not for the first time. So, my lord, my humble submission is that inquiry proceeding should proceed. Notice may go at this stage. I will file affidavit in opposition. And if he agreed with the outcome of the entire inquiry proceeding with the executive council decision, then, my lord, he could come to the this honorable court under article. That is my thought.
Okay, Mr. M.K. Chaudhary, let us senior counsel. As the term is Mr. M. Chaudhary, let the counsel. finish. Stop. Well, pursuant to memorandum of charges. Pursuant to issuance of memorandum of charges. Dated 22/10/2024. Issued by the Register Board of High Court. A disciplinary proceeding was initiated against the police. Stop. Thereafter, the inquiry officer submitted its report on 13 to. In the said report, it is indicated that the charge of misconduct brought out against the charged officer is proved beyond a reasonable doubt. The inquiry officer draft made recommendations for dismissal of service of the petitioner. He made recommendations amongst others, was the recommendation for dismissal from service of the petitioner. But the inquiry report was furnished to the petitioner by the registered Guwahati University on 13/5/2025. By a communication dated 13/5. In the said communication, it is stated that in terms of resolution number R/EC-02 of the 2025 of the 28th of the Executive Council of Guwahati University, adopted in its meeting held on 21/3, the report of the inquiry officer in connection with the departmental proceedings drawn against the petitioner has been accepted by the council. Stop. It further states that as per the resolution of the council, the report of the inquiry officer is forwarded to the petitioner for its response. Stop. Mr. M.K. Chaudhary, Senior Counsel, appearing on behalf of the petitioner, submits that the inquiry officer has proceeded beyond its jurisdiction by making recommendations for dismissal of the service in its inquiry report that was submitted on 13/2. Stop. He further submits that the said inquiry report was already accepted by the Executive Council, i.e. the Disciplinary Attorney, of Executive Council, Guwahati University, i.e. the Disciplinary Attorney, and therefore furnishing the copy of the inquiry report to the petitioner by the communication dated 13/5/2025, directing him to file a response to the inquiry report is only an empty formality. And therefore, comma, as the procedures laid down in the, this was chronicle against you, isn't it? In terms of this rules.
Yes, ma'am. Rule 9 of the Assam Service Disciplinary Bill.
Therefore, the procedures laid down in Rule 9 of the Assam Services within the Discipline and Admin Rules 1964 has been violated. And therefore, and accordingly, the further proceedings of the disciplinary proceedings should be stayed in this stage. But Mr. P.G. Fukar, the standing counsel, Guwahati University, on the other hand, submits that by the communication dated 13/5/2025, the petitioner was permitted or was asked to file a response to the inquiry report submitted by the inquiry officer. And he was given a period of 7 days to make such response. However, the petitioner by a communication dated 16/5 addressed to the registered body units had requested for extension of 7 days time to go through the same. Stop. Further, comma, by another communication dated 19/5/2025, the by another communication dated 16/5/2025, the petitioner made another request for extension of 7 days time for submission of his response. Stop. Accordingly, the registered Guwahati University by communication dated 19/5/2025 wrote back to the petitioner informing him that an extension of 5 days, 5 additional days from the original due date has been given to to the petitioner to submit his response. He therefore submits that when the petitioner has met his application for extension of time with regard to the response to be made against the inquiry report of the inquiry officer, and the same having been already extended by the authorities, the petitioner had approached this court by way of filing this witness. Stop.
May point out one, I think. That inquiry report, the last, recommending that it should be dismissed. If the executive council accepts this recommendation, then he is not a suspended employee. He is now terminated. And he should hesitate before the honorable court against the termination.
Are you the executive council?
Well, I am for the executive council. Being the
Do
standing
you have
council,
instructions on that you have accepted the termination of the petitioner? Recommendation of the
if
inquiry
that
officer.
acceptance word is interpreted that way as the learned junior council interpreted, then that termination is over, that termination. So the repetitioner is terminated.
Have you issued an order terminating the petition?
That is why it is that acceptance means receiving. So the response is required from the repetitioner.
So
That is
what
my
did they say?
submission.
What did they say? He had approached this court, without making his response. And the same would show the conduct of the petitioner. Stop. Under such circumstances, this court should not detain the president. Further submission is made by the non-standing counsel that the word use accepted in the communication dated 13/5/2025 issued by the registered Guwahati University would mean would mean that the Executive Council has only received the inquiry report and therefore, the petitioner should instead be directed to make his response to the inquiry report. Stop. But after hearing the learned counsel for the parties and without expressing any opinions on the merit of the case, but after hearing the learned counsel for the parties and also on consideration of the inquiry report, which was submitted on 13/2/2025, were recommendations for dismissal of the petitioner from service as made, as well as the communication dated 13/5/25 made by the registered Guwahati University, wherein it is stated that the inquiry report of the report of the inquiry officer has been accepted by the Executive Council Guwahati University. This part is of the considered document that the prima facie case is made out by the petitioner calling for stop. Issue notice. Mr. P.G. Foucault, learned standing counsel, Guwahati University,
For respondent 1, 2, and 3.
appears for the respondents 1 and 2.
Four is the
Four,
inquiry.
what is 4 and 5?
5 is the presenting of the.
Is it necessary to issue notice because
I can accept on behalf of respondent 5 presenting officer. He is presenting the documents on behalf of the university.
1, 2, 3, and 5.
4 is neutral.
Extra purpose. Petitioner to take steps for service of purpose on the respondent by registered proceeding.
And it can be also out to the registrar because the address will be not available.
By registered.
And also
Through the address of the register. Chaudhary, your respondent number 2 is wrong. The register from disciplinary authority.
yes, my God, I'm sorry.
Yes, you'll have to file an IA for correction.
Yes,
So the register. Guwahati. Respondents are not filed. List after 2 weeks, 3 weeks. I think.
After 3 weeks.
If it takes shorter time. 2 weeks. But in the interim, the authorities in the Guwahati University are directed not to proceed beyond the inquiry report submitted by the inquiry officer in respect of the case. You have to correct the address of respondent number 2.
Who will correct it by a filing?
Most of it.
Yes, my lord. You've not filed your affidavit 2022 matter.
Yes, madam. I'm sorry, madam. Can you give me 3 weeks time, madam?
Okay, heard, Mr.
I see data.
I see the learned counsel for the petitioner on request made by Mr. S. Thus, learned standing counsel hired the department.
Can you fix it on 23rd of June, madam?
3 weeks further time is allowed to file for the. 25th June.
23rd June.
21st.
Please, the lordship. Lordship may kindly adjourn the matter for 2 weeks, lordship. My opinion is some personal difficulty.
Okay, on request made on behalf of MU Mahmood, learned counsel for the petitioner, list of the 2 weeks.
May I please, Your Honor? Petitioners are engaged on contractual basis long back in the year 2000.
Affidavit has come or not?
No affidavit, ma'am.
Who are the other sides? Elementary.
Otherwise, my lord, there is a cover judgment, my lord.
Yes, I've seen that. Yeah, Bora. Have you seen the judgment?
It was in front.
Okay, SSA, they were appointed by the
Who appears for the SSA?
the representative before the SSA. As part of case 16, but we could have to file the representation before mission back to SSA.
Oh, who appears for the SSA?
After some time,
Let me come out.
These are those matters.
Actually, this is not to come up in the admission, it has to be in the, to be
To be spoken. To be. My lord, for your lordship's convenience, my lord, I have prepared a list of dates.
Any written argument of.
Clear argument, man. And my lord, I have compilation of the case laws relied upon for your lordship's convenience.
I think that to the day after.
Okay, then I'll list it after. Third, AK Barwa, let it counsel petitioner on request made by MS A Gayan, let it count CGC. For the responders, 1, 2, and 3. 1 to 3. After tomorrow, you want Friday?
No, I cannot take the minute, I can't take 26.
126. In the column, within inverted commas, it would to be spoken to.
Our report must have been. We invited our report.
That,
I'll hand over, my lord.
no. Bring it on to.
Oh,
the
my
session.
lord.
May I please?
Yes.
This case for the petitioners were appointed as gazette officer in Adarsh Vidyalaya, my lord, Pusagamad, after following due procedure, my lord. They joined in their post, my lord, after serving 15 to 20 days, my lord. Suddenly, my lord, their appointments were cancelled. My lord, respondent number 4, 5,
Yes,
and
the
6.
BDC.
my lord, we file a petition
My
in
lord.
opposition.
You
Respondent
filed.
number 4 and 5 and 6.
Have you filed your affidavit?
My lord, they will file a reply. We
My
file
lord,
affidavit
Huh?
at page 57.
You filed your affidavit in opposition.
Petition in opposition.
When did you file it?
18/12/2012.
18,
12.
respondent number 4, 5, and 6.
2024.
Yes. Page number 57.
That page is not here. As well.
My lord, I have filed, my lord, reply also.
When?
I have filed it, my lord, on On my lord, 28-4.
Hmm?
28,
28 for
25.
No, copy of the
okay, Mr.
on behalf of Ekara.
He has a recalled that the council appearing on behalf of Mr. S.R. Rabah. London Standing Council BTC submits that the BTC authorities have filed affidavit on 18th of Mr. J. S. Lau, my lord. London Council for the petition also submits that he has filed reply to the counter affidavit filed by the BTC authorities on 28/4/2025. Registry to verify and place those affidavits on record if found in order. List
Lord,
after-
one to clear, my lord. In case, my lord, mission director RMSA and mission director other officers has been parties, my lord, but they have not filed their response till today. I think, my lord, their response is required, my lord, for a division of the
Who appears for the mission director RMSA? The secretary, you are filing your affidavit?
This is fine.
BTC, they have already filed. Chowdhury, are you appearing for RMSA? Are you filing your affidavit?
This case, I have no knowledge, we'll file it.
You also standing counsel BTC, isn't it?
Yes, my lord, but this case has.
Okay. Mr. B. Chowdhury, and the standing counsel, RMSA. Praise for how much time? 2 weeks time to file complaint. Praise a lot. Mr. B.
Can date be speaking?
Please, Lord. But the pleadings are completed. The matter may be lifted next week for admission hearing.
Okay, on request made by?
As Gautam, my lord.
No, no, yes, Gautam, let us counsel. Mr. Matter after 1 week.
1 week.
For admission hearing.
I will like it.
Step number 26.
Please, your lord. In this matter, what has happened is that we came before this honorable court. Our grievance was that my lord, we had applied for appointment as PGP in the district of Hubri, my lord. We were selected and appointed, but in the district of South Salmara, Mankatra, my lord. And thereafter, this honorable court, so we prayed that we may be granted appointment in Hubli district. Thereafter, this honorable court asked for instruction from the secondary education department whether the seats that have been advertised in Hubli district have all been filled up, man. I know there was a submission made before this honorable court that the seats in Hubli have also.
Councillor, this petition is already disposed of.
Lordship, that is what I'm saying. This was dismissed on the ground that there was a submission made that the seats have already been filled up. Thereafter, my lord, after the dismissal, we filed a review petition on the basis of RTI information that the seats have not all been filled up. The review petition has been allowed, my lord. That is why it has been.
What is that order of review?
That order of review is just before the office note, my lord. Is there. I have also a copy of it.
So you've been given protection.
Good. Yes, then what happened? So now this is come up for the first time after the review petition has been allowed. My humble prayer is that since the two posts in the district of Bhupti are vacant, my lord, we may be accommodated there. There are three petitioners. Petitioner number one cannot have a place.
Yes,
I have to take instruction from the department.
there was a review petition was, the judgment dismissing his petition was recalled. And, direction has been issued to keep, but only one post vacant, isn't it?
Two posts, my lord.
No,
For
no,
petition
one-
number 2 and 3, the posts are vacant. One, my lord, that post is.
One
occupied.
post of, STP category
Yes,
and one PhD
yes.
in history.
Yes. History and economics. The 2 and 3 may be accommodated. One will not have a place.
Okay, yes, my lord, I have to take instruction here, my lord.
For Mr. SD, the council. On request made by you, Sharma, and the standing council, secondary. When do you want? Just a matter of 2 weeks, whenever.
Or can you take the date?
Is to give a date. On 11th.
Much obliged.
Sir, mathematics exams for the ready to personal incumbent of senior council.
So she is senior.
Can Ahmed. Can you
request
explain?
made by Mr. J. Made on behalf of Mr. J. Ahmed and the council for the petition. This is the matter of tomorrow.
In this case, I'm appearing for 7 and 8. Due to interim order, we have not appointed the other, the
Mr. Yes,
affiliated candidate.
council appears for the responsibility.
6 to 8. So,
6 to
6. So, we may some date may be up because due to the interim order, we have not appointed that.
request by the mayor. List on. Port of.
Photo, that's right.
One
Congrats.
Photo of the sheet.
Item number 3.
Maybe result lordship. But my senior who is arguing the another court matter, kindly given time. Given time being made. Given time being made. And my senior who is arguing the another court matter. Kindly given time being.
Some other than that. Here I have received an instruction on 23/5. There is a inquiry will be held. That will be scheduled on 23/5.
You are praying for area payment, the area.
Yes.
Area payment. So they have fixed, tomorrow, is it tomorrow, or Friday?
Yes.
Friday,
Publishment.
Friday is the date for
Yes,
hearing you. Have you received the notice?
yes, man. Day after tomorrow. I am no knowledge. Man.
Okay, let his senior come.
Publishment.
Number 29.
Hey, Bora. You're supposed to file your affidavit. You misplaced your affidavit and then you wanted some time to file it.
We have filed it.
Taluktar, elementary, respondent number,
Director,
director is
two months. Limited out of affidavit we have filed, madam. On 2020 we have filed. They have received a copy on 19,
20 of
20 of this month, madam. Yesterday, madam.
yesterday. That's why it's not.
Because madam, only thing is that madam, the server is down, that is why as per my
I
client.
think it came from the section, my lord, today during the court proceeding. That affidavit. Counter affidavit. Huh? I think it's item 29.
29.
Oh, you want the maintainability.
My lord,
Respondent number 2, isn't it?
my lord.
Oh, it's here. My lord, do I proceed with the case or I answer their maintainability matter? No, if you're raising maintainability, I have to hear the maintainability first. But only thing that otherwise it's barred by res judicata also. They would have drawn this when the first petition was filed by my friend. That time it should have been raised, but now it is the termination. Termination, the question of going to the tribunal doesn't appear, my lord. And that also in view of the honorable court's order. The question of maintainability taken in the wrong time, my lord. Okay. My lord, the case in brief is that, my lord, the fight revolves around 4 persons. That is 2 language teacher, 1 science teacher, and the respondent number 7, who is said to be the social science teacher. I have been my lord appointed in just 1 minute. Bora, are you filing your affidavit only on maintainability or on the merit also?
Other affidavit there, madam. So I can.
Can I help me, Lord?
Oh,
Lordship, in this pattern, my lord, my learned petitioner has filed one additional affidavit in this pattern, my lord. Tell me, Lord, this Honorable Court on 12/6/2004 directed the authority to submit the report before this court, my lord. Accordingly, my lord, this report is then supplied to all the councils, my lord. I have also received, my lord, this report is available before this court, I think, my lord. And even my learned friend has enclosed that report, my lord, in the additional affidavit, page 70. The stand of the government is here. In the instant matter, that's WPC 7515, the present case.
your additional affidavit.
Yes, my lord. They have filed on additional affidavit, my lord. They enclosed the report. At page 70, my lord, and accept it.
My lord, because the report was not furnished earlier, as we got it, then only I brought it before this honorable court to this additional affidavit, my lord.
And you know, this report is also available with me, I can furnish, my lord.
So this will suffice, Bora?
Here we have. Very well.
You're not filing detailed affidavit, isn't it?
I think now. Only thing is that they can approach the authority after section 19.
This is not the case of
Yes.
tribunal at this stage. That is the only ground.
My lord,
Detail is.
my lord, for the last 5 occasions taken time regarding for filing of the affidavit. Presently, my lord,
Because I'm not very convinced with your maintainability issue.
my learned representative against termination order. Here in this case, what happened? Now, Just before taking to the case of the audit pen and interrupting me.
No, no, see, Decca and
Let him go long, let him argue.
Bora
and
is-
he'll reply.
Cora is indecisive, that's why I'm waiting for your reply.
Some time may be granted, I will bring the record.
Report is pretty much available for this court Milord. The additional epidemic 5,000 audit pen Milord, it is that their stand is very much clear Milord. This one I will put it directed on 12/6/2024 to submit the report. That report is available for this
So
court.
that's why I'm on the report.
Yes, Milord. Why my audit pen is not aware of this fact?
One,
It's recall. Recall. Yes.
Would your lordship be pleased to see the earlier order, my lord? My lord, this affidavit, as my lord was pleased to give them the ultimate time on last occasion, it is the skin saving affidavit, my lord. To be very honest, because when they did not have anything to say or they could not say it, they just took up the mentality plea and they just filed
When
it
was the
to,
last order filed?
my lord, this honorable court in my writ petition, my lord.
14/5.
Yes, my lord. My lord, would your lordship be pleased to come page 49? Forty-nine. My lord got it.
It is the earlier run of
My lord, is it paragraph 9? Paragraph 9. For the reasons not disclosed by the state respondent number 1 to 5, the district scrutiny committee had recommended the names of the respondent numbers 7 and 8 for provincialization as language teacher, and that the name of the petitioner was recommended for provincialization and as social science teacher. As per Annexure 9 to the interlocutory application, it is seen that the DSC had recommended the name of one Abdul Haq, assistant teacher who was provincialized as a maths and science teacher. We have nothing to do with him, my lord. The service of the respondent number 7 and 8 was provincialized by notification so and so. By the same notification, the service of said Abdul Haq was also provincialized as assistant teacher, which is not under challenge. So we did not challenge. Now, my lord, would your lordship be pleased to see paragraph 10. These are the, my lord, why I'm reading this, these are the few things they ought to have answered in their affidavit.
No, that's why, Bora, are you fighting or not?
Well, that
Then in that case, I'm giving you as a last chance. I don't know for it.
My lord, only one line, my lord. Page, next page, page 50, para 11, would your lordship be pleased to see, my lord, once. My lord, page 50. Paragraph 11, my lord, down about 6-7 line, it is desirable. Did your lordship get it? It is desirable that while deciding the matter, the respondent number 2 would also examine the qualification of the petitioner and the respondent number 7 and 8, as well as the records of the district scrutiny committee to find out on what basis the recommendation had been made. It is very important. My entire case lies on this.
Yeah, between the council. Also, had Mr. B.K. Decker.
correspondent 7.
Council for the respondent number 7. Who appears for 8?
8 is over here.
And Mr. Arif Chowdhury and council. Mr. P.K. Bora, and standing officer in the 2 weeks. It's allowed 2 weeks time to file contract. That's last chance. This public weeks.
My lord, only one thing, if your lordship permits, madam. This honorable court made some observations and are kind of
That is
queries.
not for this court to say, it's up to them. If they don't make that thing, they will proceed.
Not fixing the date. Every
You want the date?
you can leave short date. That with 19th of September.
23rd.
Yes, deep privilege.
23rd of June. June. Okay. 23rd. Make it 25th, please.
20.
Okay.
Diploma.
My lord, in this case, my lord, the petitioner was in the year 2003 was appointed as an additional assistant teacher in ME school. Subsequently, in 2008, he was appointed as the assistant teacher and thereafter as the head teacher of the school in Bantar state as a language teacher. In the year 2011, earlier act, my lord, he has as a headmaster has applied for provincialization. And during pendency of the application for provincialization, the act was repealed. And the present 2017 act, the case was considered, and my lord, as per provision of the 17 act, the three teachers of a ME school was, my lord, provincialized, including the petitioner, my lord. Petitioner as a language teacher and other two as a science teacher and social science teacher. So, my lord, what happened in this case, my lord?
Yeah, a part of it, an assessor directed to verify whether the name is
I may be allowed to complete, my lord. So, my lord, kindly come to page number 30. Page number 30.
One minute.
We start from page number 29, my lord.
Just 1 minute.
Yes.
Yes, please.
Yes, my lord, page number 29 was the DLC recommendation. 29, my lord. DLC, my lord, my note. And page number 30 is the relevant part, my lord. Page number 30. The name is the Ziaul Karim is the this number 1. Ziaul Karim, number 2, Zahiruddin, number 3, Farooq Ahmed Chowdhury. So these three posts have been sanctioned, my lord. And what happened, my lord? Page number 33, your lordship will find that Farooq Ahmed Chowdhury, who was the social science teacher, his name was, my lord, while the SLC recommended to the government, his name, Farooq Ahmed's name was, my lord, due to typical error, my lord, 2 times mentioned, page number 38, my lord. Page number 38. It's very clear, my lord. Page number 38 below, my lord. It is admitted by the Director of Elementary Education that, my lord, the second table, my lord. In the second table, your lordship will find number 1, instead of the name of the petitioner, my lord, Ziaul Karim Lashkar, the name of Farooq Ahmed Chowdhury, second is Zahid, and third is again Farooq Ahmed Chowdhury, my lord. My lord, may I read between the 2 table paragraph? But at the time of submission of proposal for provincialization of service of the COP by this office, the recommendation of the SLLC as well as joint committee, the name of Farooq Ahmed Chowdhury inadvertently appeared twice at serial number 1 and 3 in the format particular for provincial service of teaching staff upper primary school as shown below. So admittedly, due to typing error, my lord, the number 3, Farooq Ahmed's name is twice entered, my lord. Accordingly, my lord, next page, my lord, lord's fine. In this regard, the DO Hailakandi had submitted a letter along with an application to and so, praying for issue of appointment letter of provincialization of service. Accordingly, the matter was placed before the SLSC meeting so and so 28/1/22, and committee decided to request MD SSA Assam to verify the records already verified by the SSA, my lord. Verify the records in respect of the name of Ziaul Karim Lashkar appeared in the DICE data in the year 11-12 and afterwards. Accordingly, MDSA Assam has furnished the DICE verification report where the name of Ziaul Karim appeared DICE 11-12 and afterwards. After receiving the DICE data from MDSSA Assam, the name was placed before the SLC meeting 26/7/22. The SLSC reviewed all records of DSP Hailakandi and relevant documents furnished by DEO Hailakandi MDSSA Assam, the committee decided to recommend the name of the petitioner Jayal Karim Lashkar to God for provincialization service as part 17 in one place of Farooq Ahmed Choudhury. This in two places, Farooq Ahmed's name is, my lord, inadvertently they admitted typing error mentioned, my lord. So therefore, God please request to kindly approve the name of the petitioner Jayal Karim Lashkar for provincialization service tutor against the Lachora Garden MA School. So, my lord, it is admitted, and my lord, this honorable court, my lord, after verifying all these, there is no need to a second report from the SSA, my lord, as per last order reflected, my lord. It is already there, my lord. After collecting the report of the SSA, my lord, MD SSA, this, my lord, letter is issued by the director, my lord. And my lord, kindly, my lord, refer to the page number 42. This is after taking all report, my lord, from verification report from the SSA, my lord.
No, but Mr. Kadir.
Yeah.
There's only a judicial order directing the SSA to get instructions.
Obliged.
So let who appears for SSA? Last time it was B. Gogoi who was appearing.
My lord, they will take the instruction, my lord. For a moment, my lord,
I've got your point.
Yes.
It's just because of the
Typing error, my lord.
there were
Typing error.
two names were inserted,
Yeah,
one
yes.
and three.
Yeah. Already, my
Your
lord, the
name was
post is
left out.
sanctioned, my lord. Repost is already sanctioned, my lord.
Let him come, we'll pick up after some time.
Full time, obliged.
If I receive instruction, okay, I will file my affidavit.
Therefore,
Elementary education, lordship.
elementary or secretary?
Elementary.
Okay, not MSCS council. MSCS Cornwall and standing council elementary education department service license receive instruction. How much time?
2 weeks time,
2
lordship.
weeks time to file contract. Can you keep it better on the preparation, no? 24 months, I'm not fixing the list up to 2 weeks.
I filed my reply, affidavit reply today, and it is on record.
Does it come?
Yes. it will come. Affidavit reply page starts from page 54. That's why I'll take some time, though. I'll take some time.
Is it? Then you wanna defend it?
If your lordship allows me to argue, then I will argue, or otherwise, lordship will fix it on 27th, the hearing day.
I'm not. Okay, I'm requesting that by the parties. Please talk to the seven.
Lord.
Yeah, my lord. We have received instruction, so sometime maybe about to find out.
First, I said, and the council. Unless if, and then the standing council.
Anyway.
And then between commission supplements. That she has received instructions. And praise for, how much time? 3 weeks. 3 weeks. It's 3 weeks time. Right. Praise and list of the 3 weeks.
Even after 4 weeks, no, also fix it. That may fix matter. But it could matter.
All the summer vacation is coming if I start fixing dates. Then you make a mention after 3 weeks, we'll get it.
Item 37.
Please, your lordship. I am in newly engaged in this matter, my lord. I request sometime to go.
Gogoi, okay, this is the matter that
After 2 weeks, my lord.
Mr. R. Barbujari, that council enters appearance on behalf of the petitioner and submits that as he has been newly engaged, he requires some time to go through the list the matter after 2 weeks.
I pray, my lord, let my name be shown in the conflict.
Registry is also directed to reflect the name of Mr. R. Barbujari as the letter council at the end of the match.
And so obliged.
My lord, I retired as a headmaster of Parabahi MD school, my lord, in the old pension scale, my lord, and my new pension scale has not been provided me. I retired on 1999. And because of the my service book, a photocopy of service book is furnished by to the pension department, my lord. And they asked for
Yes, who appears?
It is ready to file, lordship.
No chance. Have you seen the last order?
Lordship.
2/5/2025.
1 week time, lordship.
That may be fixed.
Says in the event failing to file affidavit in opposition, court will proceed to hear and dispose of the matter without delay.
And for taker pension, lordship.
Here for pension,
Yes, lordship. Respondent number 5.
affidavit is
Ready to file, lordship. Please send for hearing, lordship. Send for waiting, lordship.
why are you taking so long then? But Mr. DCC, Leonard Council. MSS Conor Leonard Government Ticket and appearing on behalf of respondent number
5.
5 submits that the affidavit has been sent for waiting. And he prays for
1 week time, lordship.
1 week time to file the same. Accordingly, release the matter after 1 week.
Lordship.
My lord, 28 may be fixed, my lord.
Who? PTC is also there. Registry is also directed to reflect the name of the legal standing of the PTC the process.
My lord, 28 may be fixed. All right.
Affidavit does not come.
No, way.
Yes.
21. Instructional notice to the. Notice to.
We'd like to file our.
ACC is the main party. But Mr.
Yes, Alim.
F. Ali Leonard Council. S. Ali Leonard Council. Mr. B. Kaushik. Then the standing council.
Element.
Elected Judicial Department and Mr. B. Chowdhury, then the standing council. This is our board allowed 2 weeks time to find this. And big item 20.
Obligement.
Lord, kindly the order dated 2/4/2025. Order dated 2/4/2025. 2/4/2025. So there is a mistake in the area proposal lot. And what?
Here, my lord, I have received only that communication that I have provided regarding people of inquiry, which is with held on 23.
Oh, there's going to be an inquiry. There's going to be a hearing on 23rd of this month.
Yeah.
And you have been served copies.
No, I did not.
So we'll list it on after 1 week.
Okay. Get me.
Part Mr.
Ezeta.
Is that Ahmed, learned counsel for the petition. Stop. Mr. B.K. Bora, learned standing counsel, elementary education department. Submits that in respect of the area salary to be paid to the petitioner, the Director Elementary Education Assam has fixed 23/5/2025 to have a hearing with all the concerned stakeholders. In as much as the petitioner had misappropriated government fund during his service period, and to order the, and in order to finalize the amount of misappropriation, they said the hearing has been fixed. So, we therefore praise that the matter be listed after the date of hearing, I retrieve by praise this law. 28 2nd June. Public.
Sir, 62 to 65, my lord. 66, my lord. All the cases are, my lord, on similar circumstances. My lord, all the petitioners, my lord, round of litigations were earlier done, and in all the cases, my lord, in the inquiry was done. All inquiry last, my lord, this is independent inquiry also, we have found that eligible to be provincial. So instruction is to be obtained by the respondent, the earlier of it.
Awaiting instruction. This is the first time after the notice is issued.
I also was issued in March, maybe coming up for first time, but then more than 2 months. But Mr. E. Kaushik, standing counsel,
Secondary.
secretary, is allowed how much time?
3 weeks.
2 weeks time to receive instructions and I'll file a list of the trainings.
All will be same.
All 5 cases are same,
Same.
up to 66.
63, all this 62, 63.
62, 63, 63, 64, 65,
66. Also.
Yeah, 25 matter, I'm not fixing this.
For orders, item number 39.
Doesn't matter if it's instruction.
Item,
Item 39.
your good name, please.
Lordship.
Your good name.
A. Hussain, I'm appearing on behalf of Dear Ahmed.
Peruse the office note. Service is not complete.
Oh, you said it's come in fractures.
Okay.
Well,
MS
A Hussein.
A. Hussein.
I'm appearing on behalf of Mr. J. Ahmed. My name is
Counsel
Nadia.
appearing on behalf of Mr. J. Ahmed. Submits that the matter has become infectious. Are you sure about this?
I have gone through it, madam.
Mr. S. Bora, London Standing Counsel,
SSC, I am appealing for SSC.
appears for the SSC.
SSC.
And Mr. Akim Oshari, London Counsel, appears for the BTC. Stop. The petition is disposed as of as us.
Number 40, 41 or two. Yes, confirm. Get rid of it. I'll pick up, 41 plus.
41.
Fine. The judgment was delivered on 16/6/2016.
Just those. Who is this 6 to 10?
For 6 and 7, my lord, Mr. D. Choikia, Mr. B. Gogoi and P. Nayak has their certificates.
6 and 10.
6 and 7. That's for the first list number. Armandra also here. Armandra, HLB 60.
Google? 2017 metric. And then
Here there is husband, my lord, review petition was filed. Review has also been finished. Earlier, my lord, finance department filed an FTP.
so
stating
Google, you are appealing for R5.
that 7. Okay.
Treasury officer,
R7 man.
finance.
Finance, but treasury man. Treasury officer.
Huh? 10,
7 and 10.
Respondent number 7 is there, presently in the committee.
Narayan Konwa, Chalia.
As per the earlier affidavit, my lord, filed by the finance department, they said that, my lord, no proposal has been sent by the education department.
Yes, Chishti.
41, 42.
I have to take it back to the follow. Why paper two?
Look at the cost list.
Lost it, kindly give me 1 week time to. I have to take it.
Line.
Mm.
17.
This will not work, Chishti. Google also.
Yes, I missed it, I think.
Okay, her tire cycle and the cost. On the Christmas by Chishti limit. Even did.
It's 3, I think.
For this model number 6. Mr. Metro. After 1 week.
6 June.
6 to 11.
On 5 or 11.
11.
On 5 or 11.
5 is it? Perfect. 11.
5 or
11.
11.
11 lot.
We have some difficulty.
11 lot.
11. 11.
My lord, regarding my lord, without the feature of the petition of the HLC examination 2010. Lord, as per notification, my lord, it is there regarding without of result my lord to be made within 6 months. And we have filed our affidavit also, my lord, kindly period. Our affidavit, my lord, filed on 16/8/2017, my lord, at page 5. And what become my lord, in fact, 2010 examination, now my lord, to 2000.
Yes, counsel, has it become infructuous? My lord, matter has become infructuous.
No, my lord, the reply has been given already.
My lord, kindly see your affidavit in opposition, my
You
lord.
take your instructions from your client, whether it has become infructuous, whether the petitioner is still willing to pursue this.
No, but the petitioner has already performed her duties directly, but some difficulties in the opposite party, the department, which are not known to the students. Some the information not given to the student, but the fault is not at all in the of the for the result.
Our result was withheld, my lord, due to non-furnishing of registration
Yes, yes.
certificate to the board, my lord.
Yes,
And my lord, kindly see our affidavit in opposition at page 5, my lord. Here, my lord, at clause 4, my lord. Regarding withheld and incomplete result. Incomplete and withheld result, if not claimed within 6 months from the date of declaration of the result, will stand cancelled automatically.
Where is the result? When was the result issued?
My lord, on 2010, my lord, examination.
But the student has not at all.
Automatically cancel, my lord.
The student has no fault actually. They have formally has done duties.
Result was declared on 29/5/2010.
Where is that?
My lord, in the repetition, my lord, at page 7, paragraph 3, my lord.
But it is not fault of the student.
Why she did not submitted the registration card, my lord? Registration was mandatory in class 9. For registration.
Yes.
In fact,
Without giving the document properly, she could not be allowed to appear. But she had already completely appear in all papers in the exam. But the result is
The last day it was listed was 2020. Why don't you take instructions from your client and see whether she's still willing to pursue this petition?
the student has
Matter has
no.
become infructuous.
No, my lord, the student has formally submitted all the required documents and appeared.
Result was declared in 2010, correct?
Yes,
You filed this petition when? 2017.
many times, many petitions are given already to the department, but when they did not. But that is why he compelled to file this petition.
You take instructions and come back. Just tell him.
আপনার কাছে কোথায় reply we have given the reply.
the reply we have.
Mister, your good name? R.K. Malakar shall take instructions as to whether the petitioner is interested in pursuing the present litigation. This capital is.
Item number 44.
Thank you, you here?
Yes, sir.
That appeal is disposed.
That outcome is not known to me. taken the after moving through the period interval. Fine.
My lord, I am appearing for respondent number 1 to 5, my lord. Say, earlier, my lord, Seba and respondent 5 for council. Regarding name correction of petitioner's matter.
Who is the petitioner's counsel?
Inspector Office.
Have you done the correction?
My lord,
Have you done the correction?
no, my lord, cannot be corrected, my lord.
None appears for the petitioner. Mr. MS,
I'm appearing for respondent 7.
he does. Well, standing counsel appears for the secondary education department.
Yes, sir.
And Mr. P.T. Fukal and the counsel appears for the Guwahati University House. And Mr. D.K. Roy. Learned standing counsel appears on behalf of the Assam.
Assam State School Education Board. ASSEB. Respondent 1, 2, 3, 4, 5.
What it say?
This is here in this case of the matter relates to the selection of the principal of Nehru HS School, Pelapur. So in the
Principal of what?
selection of the principal lot. Nehru Higher Secondary School lot. In response to the advertisement, lot, petitioner has applied for the said post and he is elected first position lot for principal lot. Now the respondent number 2 lot, find the affidavit lot. The director of secondary education, he says that to get it not. That's one out to that is the director of secondary education not. Huh?
Yes, Sharma.
Yes, ma'am. Madam, we have already filed our affidavit, madam.
Yes.
So matter may be come on matter and make up.
In the meantime, let's see, and let's see that their affidavit let's see page.
Select list has been published or not?
Yes, let's see, select list already published let's see. So can you see there in their affidavit let's see page 37 let's see. Page 37 let's see in the affidavit of opposition let's see. Petitioner name is Shahabuddin Chaudhary let's see. He is the first let's see. Page 36 and 37 let's see. Affidavit of opposition let's see.
Yes.
Let's get it let's see. Thereafter let's see in page 41 let's see. Now they are saying that the petitioner's master degree is doubtful let's see. Page 41 let's see. Accordingly, it is ordered that the officer thrown against the school shall cause an inquiry as per government decision and submit a report. They submit a report and they are saying that the petitioner's master degree is doubtful of selected principal located. That is the present petitioner located. So whether, but they did not enact the said report document. How they know that the petitioner's master degree is doubtful? Whether it is paid or the said university is paid, whether they get the report from the vice chancellor or from the registrar.
Whether you have conducted this inquiry?
Regarding that, I have no information. Madam, matter may be come on admission form, and in the meantime, I will take the instruction.
No, why is it coming forward? This is a private respondent. Notice has been served or not on the private?
Notice of this submitted. Doctor may give the, they may give the report of the, let me call for the report. Doctor.
AHMR, etc. Please. Respondent number 7. Third, Mr. NH Doctor. This Laskar level council. Also, Mr. Lee Sharma, level spending council.
Secondary.
Secretary. For the second. Para. Each court order dated 1710 indicates that Mr. H. Kumar Chowdhury accepted notice on behalf of the respondent officer. Stop. Accordingly, comma, use this method in the application column of the 2 weeks. In the meantime, you get instruction.
Yeah.
Anyway.
Lordship, as per the office note dated 21/11/2024, the service of respondent 5 and 7 is deemed to be completed.
Office.
Office note dated 21/11/2024. But otherwise, this is a matter of delay, Lordship,
5 to 7.
5 to 7.
Yes.
The private response.
Here, our lordship may interpret its order, man. Interpret its order passed by the original.
You will find at page 29, the
Start
issue
from
note.
page 29. This
And the
case was dismissed for delay.
case was dismissed for delay, Lordship. The operative part is at page 32, Lordship. The second last paragraph, Lordship. Petitioner having knowledge about the disposal of writ petition by the Honorable Guwahati High Court and direction to approach Educational Tribunal on 24/5/2018 knocked the door of the tribunal on 29/8/2019, that is after 1 year, 3 months, 5 days. When the case of the petition is set aside by an order passed by the government, officer of government, this case is to be covered by Article 100 of the Limitation Act. Here in the case in hand, petitioner having knowledge of the disposal of the writ petition by the Honorable Guwahati High Court and its order dated 24/5/2018 that the petitioner are to move before the Educational Tribunal, even not approach before the Education Tribunal within 30 days of the order passed by the Honorable Guwahati High Court, and file the application after 1 year, 3 months, 5 days of passing the order without showing any reason for delay in presenting the application. Therefore, the present application is barred by limitation as delay in filing 1 year, 3 months, 5 days, not having not explained at all.
Anyway, let it come in the equation because let us give a chance to 5, 6. Third MS.
8 alone.
8 allocation and council verification. 8 alone. There was the proceedings of the Lavazima project. Did you want to? The notice on respondents filed the solution. Use the letter in the admission column.
After, may I pray for a date from 2020?
Give a date of the one.
Right. On 6th of
What?
time, big item.
You have any instructions? Go ahead. Third MG Katir the council for the petitioner. Stop on request made by Mr. B. Gogoi and the standing council. SSA. How much time? It's a matter up to 2 weeks to enable him to receive instructions. See, Gogoi, this is purely a typographical mistake committed by the director. Petitioner's name was removed and the name of One person must enter twice. This is the only issue. Anyway, so let us not prolong this. Yet, definitely after that, it's a matter of 2 weeks, huh? Registry is also directed to reflect the name of the standing council. That's assessor in the process.
Well, I pray for a fixed date, well, otherwise it is difficult to display a matter.
The 24 matter, I'm not fixing this on 24 and 25. But you can make your mention after the date expires.
The fortnight to yeah, maybe not item 49 and 50 may be action 43. As we need to get instruction from the petitioner.
Then how about 51 and 52 is only?
I am for 51.
You're the petitioner's counsel.
Oh my God, I'm for DTC.
Yes, you are praying on behalf of
What? Mr. Arbino. Oh, Mr. Arbino.
on request on behalf of Mr. Abraham, Leonard Council for the petitioners in WNC 50, 2625 of 2021 and WBC 52 of 2021. Use these matters after
Here, one, what I,
one.
freedom.
Not a place for the petitioner. This after weeks. Oh,
In this method, minus 2 weeks may be granted to get the inspector.
last time also you were given 2 weeks time. Okay,
And
third
inspector
master,
I'm allowed,
M.
allowed.
Leonard Council. Mr. U. Sharma, Leonard Council, appealing for the service. It's about 2 weeks time to receive.
Statement.
This on 16th.
Item number 5. The review by the state. That will take some time. Can you please pray for 2nd of June, Malak? We got a 3rd of June.
I am the commissioner. For the last 30 years, without salary, I'm doing service, and for 2013, my all the colleagues getting the regulation benefit, So 3rd of June matter may be for the
Where's the order?
Order page 59. Basically, we are seeking review of page 62, Malak. That one paragraph. Most important.
Page 62.
Page 62.
The review petition. That is the affidavit. I think. Page 61, madam. The paragraph starts on page 61, paragraph 5. Paragraph 4. Facts are at paragraph 4.
Order page 60, my learned thing turning to page 61.
Yeah. 61, madam. Here, madam, in this case, madam, it was recorded that the district scrutiny committee recommended the name of the petitioner, madam. Whereas, madam, from the record, it is apparent, madam, only the inspector of school has passed an order in favor of the petitioner. District scrutiny committee yet to have acted upon this order passed by this scrutiny. And, madam,
Third week also, the standing council, secondary,
yes, madam.
secondary education department
Review petition.
for the review petitioner as well as Mr. P.K. Deka for the response.
Respondent. Third of June.
Mr. Latter,
Third of June.
third is
The
not
5th of June.
possible.
madam.
Mainly
Fifth-
cases are this.
5th of June, Kali.
Fifth year.
Just that part, isn't it?
That part, my lord, and because of that fact, the finding of the court was that he is entitled under section 4 of the 2011. Now that's a settled law, my lord. That he is not entitled because for getting the benefit of deemed provincialization, the procedure under section 10 has to be complete of the 2011. Like, please, these are
Hello, I will make the submission on 5th of December.
In this matter, my lord, an order is in June whereby the managing committee of the school has been resolved, my lord. There are two school, one school approach in another writ petition. That writ petition has been disposed of. In the earlier of it, I have submitted the order, and this matter is forwarded by that order, my lord. So that order reflected.
Who appears for the other side?
Peter appeared on the last occasion, my lord. Let's see that.
Khatanier was
Yeah, my
appearing
lord.
16/5/2025. Khatanier was there. Kaushik, do you have any instructions?
I have
The order is there, my lord. In the order, it clearly reflected that in this school also, my lord. In this is school also before dissolving the FMDC, my lord, no notice was issued to the managing committee, my lord. At page number 3, my lord. This order is of, my lord, 27/5/2025. The last copy I have handed over.
Here also, they've got the same order.
Yes, my lord.
You've got the same
At,
letter.
yes, my lord, at page, at paragraph 8, my lord.
Who is Das?
Yes. In that case also, my lord, this order has been already satisfactory. They took time, my lord.
9/10/2024 was the order.
9/10.
next week, madam.
I'm just checking.
I take no point.
What's the order of 9/10/2024?
Yeah.
Mr. Counsel, well, have you read para 9 of that order? Para 9.
Which order, my lord?
The order which you place WBC number 5605.
Yes, my lord. Para 9.
Read it. Yes, read it.
But the school management and the department committee has resolved without taking any notice to the authority of the view that the said written order is not sustainable as the same is in violation of the principle of natural justice. Accordingly, the unto not a by which the FMDC has been resolved is thereby settled. Yes, ma'am. In that case, my lord, the order was settled.
In that case,
That's it.
this, by this order, two school
Yes,
SMTCs.
yes, madam.
What does this para 9 talk about?
Setting aside.
It's a blanket setting aside,
Yes, madam, but,
automatically everything is gone, including your school.
It's not prescribed in my school, madam. No. The condition is not prescribed in my school, madam.
Read it. Para 9.
Because in spite of that, madam, I observe that, madam, set aside that, that order is also applicable in this case also, madam. I observe that, madam. In spite of that order, in my school, madam, the condition is not reputable.
Which school?
It's Tintanga High School. Looking.
Perhaps for the para 9 it to be read with para 2.
Para?
Para 2.
The case is about the Dollarpur High Secondary School, madam. We have a challenge of 5 Dollarpur High.
Okay, then
May not be the order in them.
this is practically a covered matter.
Okay. What do we take up?
Make sure the
I'll
class
take-
comes or you can come. also.
I'll take them. I have picked.
Okay, heard MI received from the council. On request made by Mr. B council, level council. Level council, level standing council.
Secondary.
When do you want?
We need an expert.
Give a date next, on the motion.
On 30. 30. Man. Item number 50.
So, Chairman, my lord, the council for the respondent number and 1 and 2, my lord, the standard appear.
Oh, the contempt matter,
Contempt matter.
A voter who running for the. Nayak, you also there.
Yes, Dr. I'm here. In fact, today morning also, they give me some instructions for it. They're processing the file lordship. And they're right now lordship, although initially an order was to keep one post vacant for his at one. For some reason, it was not kept. And now they are searching for an additional alternative arrangement. And very soon, doctor, they are going to be.
Heard Mr. D.K. Roy.
My lord, on behalf of MDEC,
The council appearing on behalf of the same Deccan and council. The CP Nayak, the council appearing on behalf of the respondent number 1. Submits that the case of the petition is under consideration. And he prays for.
Legislative after 3 weeks of in the language.
For 3 weeks time to enable them to receive updated list.
My friend is appearing for 2
Yes,
years.
up to 2 weeks. MS. Yes, Bora, Leonard Council appearing on behalf of. Arbi Bora appears for the respondent.
my lord, I pray for my lord, death.
Will come out after 3 weeks.
Obliged.
Alright. Lordship, here in this matter, I have filed by power on behalf of the respondent number 2, Lordship. Lordship, here, Lordship, the respondent number 1 has given us the direction, Lordship, to Lordship, the last paragraph. So, Lordship,
You have directed for regularization of your leave period.
That is was the order which was passed. So copy may be served. In the meantime, let come up on Monday.
yes, Lordship,
Let them comply with the order.
the director will comply, Lordship.
No, this was issued on 25th,
Yes, Lordship.
yesterday.
So, Lordship, let it
Let
come
them
on.
give the director at least 1 or 2 weeks there.
Because I'm retiring on 31st. That is the reason why it come up on Monday or Tuesday.
Monday.
Okay, heard Mr. S. Count, then the council. Mr. D. Obamania, then the council appearing for the respondent. Has furnished an order dated 25/2025. Issued by the Secretary to the Government of Assam Higher Education Department. Wherein the Director of Higher Education Assam has been directed to take necessary action for regularizing the leave spirit with effect from 1/1/2000 to 30/11/2005 in respect of the petitioner as per the Assam Non-Government College Management Rules 2001. And the governing body, Handicrafts College, Guwahati, shall take necessary action for regularizing the leave period with effect from 1/12/2005 to 6/10/2006 as per the Assam College Employees Provincialization Act 2005 and rules of 2010. He accordingly submits that the director would be taking steps. Would be taking steps within a few days. So, accordingly, list the matter on when?
Monday.
Monday, can you do it? List the matter on.
Or else Wednesday, 28.
Yeah, 28. The order dated 25/2025 is placed on report. Finish.